Out of list mention nothing.
Out of his list. My lords, arbitration application was disposed of by the Southern High Court, and the Supreme Court Justice Madan B. Lokur was appointed an arbitrator.
Give it to registrar. It will come up.
But the mandate is expiring tomorrow. Any possibility of branch motion?
We'll see what can be done.
Much of it.
Latest it can come up only on a Friday, mister. This Friday it will come
I
up.
admit, my lords, 31st tomorrow being the last date for mandate. That's the reason I'm.
You were waiting till 30th of August, right? No. Why? I mean, waiting till 30th. You knew, when did you knew that mandate will expire on 30th?
Last 24 months.
When did you know that mandate will expire on 31st of August?
That was a delay on our part.
No. When did you know?
It was there in the last 15 days.
15 days. This court was sitting single,
I have to call.
causing inconvenience to the court, right? I mean, all the time. Yeah?
We'll wait.
Friday.
Much of it.
My lords, kindly, my lord. If my lords are coming in line, I will wait.
No, whatever. You have said, we will hear you.
My lords, this is a similar matter as that of the MBBS admissions, local, non-local. That was about the admission into education institutions. This is about.
It will be decided.
No, what my lord. The difficulty is this moment. We filed it almost a year back. Exam was conducted.
Final hearing, this thing, please, if we.
My lord, it needs to be.
Don't decide.
The issue needs to be addressed, man.
One second. Old matters, final hearing you want, we have been telling everybody.
No, some of them are there for admission also. All of them are there for admission. It is not admitted. The Honorable Court wanted to dispose of at the stage of admission only. Counters are filed.
We will admit it. If you want admission right now.
No, my lord. I want the disposal, my lord. It's a covered matter. That's why I am making a mention.
Tell him that finally.
Covered, please move an application. Please move an application.
As well.
No, see, we have been telling that we will not list the matter finally by way of a mention every day. So the rule cannot be different for you, Mr. Cannot be different. What they will say that
No. I'll
senior person court has permitted and juniors tell us that court tells that you file an application. Rule remains the rule, and we hope that.
Only permitting with the lunch motion today, no mention day your matter pertains to municipality.
Or
Yesterday they came and.
They are demolished. They have demolished.
Not demolished. If today, if lunch motion is not given, they will demolish whole my.
Whole thing. Your house.
Yes, now.
Yes, lunch motion.
Publish.
Some other bench, right? As per roster.
I permittum of lunch motion, my lord. The medical admission regarding the A category counseling, your lordship, my lord.
It will come up, Mr.
But it is already yesterday numbered, my lord, not listed.
Tomorrow.
MBBS admission there. It's numbered there. Not listed.
And then numbered, then it will come tomorrow automatically. Let us test the system. We have always been told if a petition is numbered, it comes upon its own the next day. We don't know what for you people are mentioning. And if it is not numbered, not listed, please mention. We will see what can be done. We have been assured that the system is such, next day matter comes up.
Tomorrow.
Don't be desperate. Yes.
Auction proceedings are mandatory.
Final hearing.
Today auction is scheduled. Lordship, I exhausted my
Auction Surface Act.
DRAT and that matter was not heard. That's the reason there is an urgency in this matter, your lordship. Today the auction.
We can't hear you, please switch on the mic. Please switch on the mic, I think mic is off.
Yeah, so sorry.
Ah.
Today auction proceedings are there. I filed a writ petition against that.
What have you done to auction so that your property is being auctioned? What have you done?
I tried exhausted my remedies before DRAT.
No,
that's the reason I could not find time to come before.
You took loan, right? You took loan and did not pay. That is why you property.
In the auction purchaser, I was delivered a position against payment of total sale consideration.
When?
Long back. That was in 2018. And
what has happened today? What has happened today? at 10:30 to say that it should be taken up, otherwise I will die.
No, my application was not taken up for hearing by DRAT against SCA. That's the reason I
Tomorrow.
could not, that there is an urgency.
Tomorrow.
We can,
Tomorrow.
I leave it. Much obliged.
Some application or final hearing?
No, is it a fresh matter?
Fresh matter?
Fresh matter.
When did you file?
Today,
Tomorrow?
no, I leave it.
Simple, right? Yes.
At least I
Fresh
can,
matter.
that protections are not.
People are getting
I can
the
understand.
old matters
I'm
listed.
sorry, but I'm helpless. I tried my best. I'm much obliged.
My lord, I am the petitioner.
Yes,
I am the petitioner, a gold medalist, my lordship.
old matter.
Gold medalist. I am telling, gold medalist, my lord. Petitioner, gold medalist. Myself. As
No,
per the orders of,
we don't decide any case on the basis whether silver medalist, gold medalist, first class, second class, supplementary. We don't
kindly
decide.
listen to my submission. As per the honorable chief.
What do you
Justice order-
want? Final hearing of a case?
No, no.
Old matter, fresh matter.
Telling, my lordship,
Is the
as
matter
per
on
the-
board today, you know, it's a no mention day. Only for demolition, dispossession, we give permission.
okay, it is not a mention.
If you see on Wednesdays, it's a no mention day.
Tomorrow, obligement, tomorrow.
Whatever it is, you can meet registered judicial. What is your matter? You can talk to him.
No, there are the honorable chief justice orders are there to list before the DB1.
He will also understand. Please show it to him. What is the matter?
Our matter is there, orders also there, honorable justice orders.
We cannot permit you to mention on a no mention day. Only urgent matters we have entertained.
Tomorrow I will come, my lord. Tomorrow I will come.
No, don't come in case of an old matter. File an application for urgent hearing. The rule applies to everyone,
No.
including party in person.
Orders already there.
Then go with the orders already there means. Then why are you standing if orders are there? Yes, next.
Yes.
Forget about that. That practice is gone now.
Wait, please, ma'am.
Ah.
Well, this is an appeal under section 37 of the Arbitration Conciliation Act, read with section 13 of the Commercial Court Act.
Yes.
My lord, the unsuccessful petitioners in a section 9 petition are the appellants before your lordship. Let's a case where, my lord, the appellants, my lord, are owners of an extent of approximately 289
Para
acres of-
40. Para 40 of the order passed by learned single.
Yes,
Please read for our benefit.
yes, my lord. Yes, my lord. In the present case in hand, it is undisputed fact that there is no written agreement between petition number 4 and respondents in respect of Schedule B property. And in the absence of any agreement between the parties, this court cannot assume that there is consensus between the parties. As such, the present petition is not maintained in respect of B schedule property, and accordingly, point is answered. As far as A is concerned, both I will submit. As far as
No,
B,
so in respect of B property,
Yes.
there is an agreement.
A property, there is an agreement.
B,
B, there is no agreement.
correct?
B, there is no agreement. There is no.
Say so that finding is correct, 40.
That finding, my lord, is correct. But, my lord, we have relied on two judgments of Supreme Court with respect to group of companies doctrine, and said it is the respondent's case. My lord, they filed a suit before the court in Kerala, where they have contended that with respect to B schedule property also, this is a part of the group company and it is executed for that purpose. Those judgments are not even considered, my lord, which we have cited.
An agreement.
Underlying agreement is one. Then only fluoro control and zero kilogram
Yeah.
apply.
We don't think that this doctrine which you are saying applies to the facts.
I will demonstrate, my lord, subject to.
Please
Yes,
demonstrate.
I'll just pass on, list of dates.
You mean to say that in respect of supposing High Court also you can file, it is not subject matter of agreement
No,
between the
that-
parties. You
that
can
is not-
file a petition under section 9 in respect of High Court also, building also, which is not subject matter of agreement between the
That is
parties.
not, my lord, my submission.
This is what para 40 says.
My lord, para 40 is with respect to land, my lord, which is given.
And you have
on lease.
admitted that it's correct.
Yes, my
You are seeking an interim measure in respect of B schedule, B property.
My lord, originally it was granted for A and B also. Interim measure for A and B also was granted. So, my lord, after dismissal of this, my lord, now he has once again started, my lord,
So are
agricultural
you
operation.
confining your claim to A property?
My lord, we are seeking for both A and B. I will demonstrate, my lord, how I am entitled for A and B, subject to my lord's.
Yes, please.
I'll just pass on, my lord, list of dates.
We have read it, Mr. Give it. List of dates. So that means final hearing, right? List of dates. Yes,
There was an
please,
order in my
please.
favor until the pendency of the section 9.
Please. No, please go ahead. Yes. You are being heard on admission,
Yes,
which can result either way,
I have only,
either admitted or.
I have only, my lord,
Yes.
given the brief dates which are relevant for the present
Yes,
inquiry.
please. Very good, very good. We appreciate.
Yes, my lord. My lord, on 30th
Yeah.
July 2021, a term sheet came to be executed between the appellants 1 to 3 and respondent number 1, agreeing for executing a leave and license agreement for cultivating cardamom in an extent of 288 acres approximately. And respondent number 1 paid license fee of 1 crore 15 lakhs 20,000 for the period so and so. Thereafter, my lord, in August 2021, the respondent number 1 formally requested appellant number 4, a sister concern of appellants 1 to 3, for using another extent of land at measuring so and so for a limited period up to December 2021, and the same was formally agreed by the appellant number 4. There is no dispute, my lord, that there was no agreement between the appellant number 4 and the respondents with respect to B schedule property. That, my lord, 3. Appellants 1 to 3 entered into leave and license agreement with respondent number 4 in respect of Schedule A property. On 1/8/2022, license fee of rupees 1 crore 15 lakhs 20,000 for the period so and so became due. On 27/9/2022, appellant 1 to 3 issued notice of default under clause 39.2 of LLA, calling upon respondents to pay a sum of rupees so and so. On 6/11/22, respondent number 1 issued 3 post-dated checks totaling a sum of rupees 80 lakhs towards part payment of license fee. On 19/1/2023, the checks issued by the respondent number 1 were dishonored due to stop payment instructions, and the appellant 1 to 3 have initiated proceedings for offence under section 138 of so and so. Yes, my lord.
This person is ready to approve this standing.
You are appearing for.
On caveat,
May please, Your Honor, I appear for all the respondents in this
on
matter.
caveat.
Yes, my lords.
Huh?
Yes, my lords.
Also supply him a copy. We will have.
Yes, my lords, already copies are.
Copies were given
My senior is
18.
indisposed of. My lords, may kindly grant.
I know this thing, Mr. We are inclined to examine so far as Schedule A property is concerned. Tell us only how you are entitled to B.
Yes, my lord. Schedule A property, my lord.
B. In respect of which there is no agreement.
Yes, Schedule B property. My lord, this Schedule B property and Schedule A property are contiguous. There is only a road which runs in between. Now, my lord, there are some quarters in Schedule B property which he says are required to, my lord, do the cardamom plantation in Schedule A property. Because of the fact that these two, my lord, the activity is connected.
You are in possession by virtue of an agreement.
Look, my lord, I am the land and owner. My lord, 4 companies are owners of this 288 acres and also this 14.5 acres. My lord, he is only a licensing. He is only a licensing, my lord.
Second license agreement you have, that is granted.
Yes, my lord.
The license is valid up to what?
2031, my lord. It is terminated. my lord.
2031. No.
It's terminated.
Session under the license was handed over to respondent.
It's what, my lord, division bench of this honorable court has held. As far as license is concerned, it is governed by section 52 of the
No,
easement.
we are asking you as a matter of fact, is there any stipulation in the agreement about delivery of possession? Division bench.
There is no such stipulation.
So they are not in, according to you, only license was executed, possession was not delivered.
My lord,
This is your case.
something like this. And I respectfully submit, my lord, this. My lord, the license, leave and license agreement is for the purpose of cultivating cardamom, my lord, in this area.
So who will cultivate? He will
He
cultivate.
has to cultivate. He will come, do this particular thing and go. That is the license, my lord, which is given to him, for which he will pay license.
Therefore, possession not given.
That is what. my
It's
lord,
only license to enter the
Yes,
place
sir.
and
Yes.
to collect the cardamom and go back.
the activity and go. My lord, that's what.
Ah.
Now, my lord, what he is doing is, that's what. my lord,
That's what we are asking.
I am obliged.
You are saying division bench.
No, I am obliged.
Division bench cannot hold.
No, I am obliged.
Where is that agreement that he will go and come back and again go and come back? Which page?
No, that is the legal license agreement, your lordship will find.
Page 94. Page 94. Oh, photographs are almost like not visible, mister.
Yes, my lord,
We would have appreciated if this thing, we could see who is the gentleman.
that is what I.
Who is like black, all this thing. Lighter vein, Mr. Don't have nothing to do. Which clause?
I will just.
Hmm? Which clause?
But,
No, but
page 105,
some comes and goes back.
page 105 will recital.
100
Page 105.
or yes.
Whereas the licensee has requested the licensor to allow them to occupy and use the scheduled premises to cultivate cardamom as licensee, and the licensor has agreed to allow the licensee to use the premises only in the capacity of a licensee and to occupy the same without any right, title, interest or claim in scheduled premises or any right or interest in the licensor in the scheduled premises. This is the condition, my lord, under which it is granted. Then, my lord, clause 2 at page 106.
Second place respondent information. And you are claiming under section 9 that you are in possession
Yes.
and they should be restrained from interfering.
Difficulty is this, what we are
No,
doing is,
this is what you have prayed in section 9, correct?
section 9, what we have said, restrain them from conducting activity.
No.
The order of first.
Where is the prayer?
Yes, my lord. The section
As
9
we saw.
petition is at page 57.
The interfering with the possession of petitioners over schedule A and B property.
Yes, my lord.
Restrained from entering. This is what it is.
My lord, he has defaulted in payment of license fee, which is subject matter of arbitration.
Mister, we have to be fair to you.
Yes,
Two choices.
yes,
Either get the arbitrator appointed, file a petition before him under section 17,
yes, my lord.
or we will pass an order. Either choice we at the outset we gave you. Then go ahead.
I will, my lord, I will submit to that subject to, my lord, kindly see, my lord, what I intend.
Ah, yes, we will hear you.
We told it, only not on the merits, my lord. I'll submit, my lord, the difficulty which we are currently facing, then my lords may decide, my lord, on that aspect. The application under section 11 is coming up, my lord, on Friday before the Honorable Chief Justice. Now, my lord, that they are seeking time for filing counter, that is the situation there. Now, situation which we are facing is after dismissal of the section 9 petition where there was an injunction restraining them.
You
They
are
have
saying in
started-
section 11.
Yes, my lord, they are merits.
Argue on Friday. We will not grant adjournment. We are putting you on notice today itself. 48 hours before.
But he is harvesting the cardamom right now when I am arguing the matter. That's the only difficulty. 120 acres he is harvesting, my lord. That's the difficulty. Otherwise, I don't have to press for this. After filing of this appeal, until then, my lord, he kept quiet. Because there was an injunction. My lord, 120 acres
No,
approximately.
under the license he is entitled to do so.
No, only when
If he is committing an offense under IPC, like taking away somebody else's property is an offense under IPC.
Well,
He is first information report against.
my lord, there was
If
so many- my
he
lord,
is
there are-
committing theft,
he has, my lord, he has violated forest laws for which the action has been initiated. He is being prosecuted. Many other cases are going on, my lord. I am only on the question of, my lord,
No, we are-
protecting the produce.
Mister, we are this thing, protecting the produce.
Yes,
So
sir.
what do you do with cardamom? That you sell it?
Yes, my lord.
Maintain an account in respect of cardamom which you pluck from this thing.
Yes, I'm willing for that. Yes.
Let him pluck it,
Yes,
but he shall maintain an account.
and not
which will
use
be-
it, my lord. Not use it, my lord, until, my lord. If he uses the money, my lord, again.
Everything cardamom
my lord,
and everything is, Mister, please
Yes.
understand, we believe that cardamom must be having a shelf life. Eventually, everything comes in terms of money.
my lord, that is why I'm saying.
If he has wrongfully plucked cardamom you will be entitled to damages which arbitrator will decide.
Yes, yes.
Correct? So we will say that keep an account so that your interests are protected. He will furnish an account before the
Arbitrator,
on the first date of hearing and shall continue to do so.
he will take that as an order.
Till you file an application under section 70.
Yes.
Or this arrangement will continue till you file an application under section 70. We grant you the liberty to file section.
Very well.
Correct? Fine. Fair enough. Can we pass it as agreed order?
Yes, madam.
Yes, madam. This appeal under section 37 of the Arbitration and Conciliation Act 1996 has been filed against an order dated 24 July 2023 with regard to
Yes.
cardamom,
Yes.
that you have to pay license fee.
Yes, my lord.
You can't. We have heard learned counsel for the delete jointly submitted. It's an order on merits, sir. In respect
yes.
of Schedule A, Mr.
Yes, yes.
It's an order on merits in respect of Schedule A. Schedule B, we grant you the liberty to file a suit.
No, my lord, not suit, my lord. I'll pursue that before the Honorable Chief Justice in the application.
No, then you section 17.
Yes, yes.
All right.
Yes.
We grant you the liberty to pursue Schedule B under section 17.
Yes, yes.
And Schedule A, we are granting an order.
Yes, yes.
Dispute has arisen, right? Huh? Hence this appeal. Paragraph. Learned counsel for the appellant. Learned counsel for the appellant submitted that under we have considered the submissions made on both sides and have perused the record. This paragraph delete, madam, jointly submitted. Correct. Yes, madam. Consider the submission made on both sides. Under the leave and license agreement executed between the parties, the possession of, it appears that the possession of land has been handed over to respondents, which is evident from clause capital B of the leave and license agreement, which is reproduced below for the facility of reference. Quote, madam, this page 105, these lines, quote, apparent from so and so, which is reproduced below for the facility of reference. However, the right of the respondents to pluck cardamom is not unfettered and is subject to payment of the license fee. Full stop. Admittedly, in respect of the Schedule A properties, leave and license agreement has been executed, and therefore the dispute between the parties has arisen. Full stop. It is also not in dispute that respondents are in possession.
Yes, my lord.
Respondents are in possession of
What we are saying, we are
Schedule A land. Respondents are in possession of Schedule A land, which is also evident from clause B, capital B of the leave and license agreement. Therefore, it is directed that till the arbitrator decides the petition of the appellants under section 17 of the Arbitration and Conciliation Act, the respondents shall be at liberty to pluck the cardamom under supervision.
Yes, my lord.
Under supervision
of the manager appointed by the appellants.
Under the supervision of manager. This is the agreement.
Yes, my lord. That is the LLA. That is the leave and license.
Under the supervision of manager appointed by the appellant as provided in clause. Which clause? As provided under clause dash of leave and license.
Clause 17, my lord, is a representation by him as to how we should do that.
There is leave and license agreement, Mr. Which
Yes,
clause?
page 112.
112. No, this is no nuisance.
This is a prohibition, my lord, and that
that supervisor appointed by. Achha, we can do. It's correct. Delete. What have you written, madam? No. Just delete. Therefore, last sentence. No. What last sentence? No. Delete this also. Previous one sentence, madam, after deletion.
Admittedly, in respect of Schedule A properties, leave and the license agreement has been executed and the dispute between the parties has arisen. It is also not in dispute that respondents are in possession of the Schedule A.
It is admitted, not in dispute.
clause 34 at page 120.
Admitted, not in dispute. Again, you are that admittedly, not admitted. Admittedly.
Of the Schedule A land, which is also evident from clause B of the leave and agreement, leave and license
Agreement paragraph.
My lord, sorry to disturb.
The dispute is paragraph. The dispute between the parties has arisen with regard to plucking of cardamom and payment of the license fee, right? License
Yes,
fee.
yes.
Full stop. Therefore, in the peculiar facts of the case, we permit the appellants to appoint a manager who shall supervise the work of plucking of the cardamom. However, the respondents shall only be entitled to pluck cardamom on payment of license fee. Payment of license fee. Needless to state that aforesaid interim arrangement which has been which indicated above is in respect of Schedule A property and is subject to and is still and for the period till arbitrator decides the petition filed by the appellants under section 17 of the Arbitration and Conciliation Act. Paragraph. Needless to state that the appellant shall also be entitled to claim a relief with regard to Schedule B properties in his application under section 17
Yes.
of the in the application under section 17 of the Act.
Yes.
We have said Act, right? In the for the aforementioned reasons, order is passed by learned single judges set aside. Appeal is disposed of.
Oh, yes, my lord, your lordship may direct the respondents to, my lord, maintain an account of the proceeds, my lord, kindly.
Are this all being done under supervision, plucking on payment?
Very well.
Where is the question of account? You will know what is the account
Very
because
well.
amount will be paid to you only.
Very well. I am obliged.
With consent heard finally, you said. In the beginning, that this person has entered on caveat.
This writ appeal is filed, my lord, against the orders passed by the Honorable Single Judge in WP number 7719 of 23, dated 30/6/23.
Suit is pending.
Suit is pending, I am not a party to that.
No, no, but you can implead yourself, ask for vacate.
Lord, in a specific performance,
No, no. What is the suit you do not know?
no, the suit is filed for specific performance, my lord. Lord, I purchased under registered sale deed. Subsequent to the purchase, my lord, the interim order is passed. And my name is entered in the Dharani portal. Now, in Dharani portal, my lord, they blocked holding that this is subject to the result of the suit, my lord. The learned single judge, your lordship,
Injunction order is passed, they are bound to implement it.
your lordship, my lord, your lordship may kindly consider my respectful submission is that the injunction is against a persona.
True.
My lord, I'm not bound by the order.
Property, it is, though it is in respect
Section,
of in
my lord,
person.
how the learned single judge dealt, my lord, page, Para 8, page 15, my lord, your lordship may kindly see.
Yes.
Para 8, page 15. May I read, my lord?
Yes.
The above facts and circumstances projected makes it abundantly clear that a party in whose favor an agreement of sale is existing is trying to establish his legal and justifiable right. The petitioner, on the other hand, is trying to ascertain his right in dealing with the subject property in the capacity of a lawful owner. The inconvenience, this is important, the inconvenience which the plaintiff to the suit may suffer would be much higher than the inconvenience which the petitioner would be put in case is prevented from entering into any conveyance with regard to the subject property. It is not the case that if the petitioner prevented from enjoying the property. Lord, the agreement of sale does not confer any right. Section 54 of the Transfer of Property Act says that it does not create any right or attached property. What the section 54 of the Transfer of Property says, my lord, it does not of itself create any interest or charge on such property.
Mr. Entry into revenue record as per our limited understanding doesn't create any right in favor of anybody and a civil suit is pending, it will be subject to result of this thing.
Blood, I'm not a party, your lordship rise. Here is
No, no,
not to the
this
registration.
is the law, right? What has happened is that this is pertaining to an entry into revenue record, correct?
This is by incorporating entry of the interim order, blocking my registration, not an entry, mere entry is not similar. It is the.
No, so you are claiming title on the basis of an agreement for sale?
I'm basing on a registered sale deed. A third party.
So your document sale deed is not being registered by virtue of by order passed by learned single
Yeah,
judge.
I make it clear. I purchased in the year, my lord, my date of sale, registered sale deed is 21/9/2021. And interim order is passed 4/8/2021.
No, the suit is prior to your interim order.
That's from lord.
2020 is the suit.
I am not a party to the suit, my lord. Your lordship may kindly consider, if it all there, section 52 sale takes place. 54 says.
No, who has filed the suit against whom?
My predecessor, my vendor's predecessor in third party filed suit against my predecessor's vendor.
So then your title is dependent on the civil suit, outcome of civil suit. You are bound by doctrine of lis pendens. This is after institution of suit you have purchased.
I fully agree, my lord. Your lordship. My grievance
Suit was filed when?
2020, my lord.
Suit filed when?
2020.
No.
Some third party filed.
Third party means your vendor filed.
No.
Some third party against vendor.
Against my vendor's vendor.
Vendor's vendor.
Yes, madam. And interim order is passed on 4/8/22, madam.
1 minute, filed civil suit in 20.
Yes.
Then specific performance.
Yes.
During pendency of that suit, you purchased from this property.
From third party.
Third party.
My limited.
No, not third party. Vendor, who is a party to the suit.
No, my lord. We already sold to X, from X.
No. So this thing, vendor is not a party to the civil suit.
But my vendor is not a party. I is on the date. My vendor's vendor is a party.
This is not.
Yeah, so it gets vendor's vendor. So you are governed by section 52, not.
52, Milad comes. 54 says that. 54.
Section 52 TP Act, you are governed.
Yes.
Correct? So your title, now what the single judge has done?
Single judge para 8, your lordship may kindly say.
What, you tell us, you are a senior counsel. Tell us, you are here to
Single judge
assist.
says that the inconvenience caused to the plaintiff is higher than the inconvenience to the petitioner.
No. What has he done? Inconvenience is for fine. What has he done? She has done.
The learned judge, relying on the judgment of the trial court, Milad interim order, that a valid order is passed in a suit, civil suit, therefore it is binding on
Who
the
is this Sheelam Rajaya?
petitioner, writ petitioner.
No, petitioner obviously, but who is he? Your vendor's vendor
He
or
is a
whatever.
purchaser. He is the purchaser.
Purchaser means you.
Yes.
Your petition has been
Yes.
disposed of.
Yes.
Dismissed. Your petition has been dismissed.
My petition is.
So you filed a petition
Writ petition.
saying what?
Questioning the blocking of the registration in the Dharani portal.
No, blocking Dharani portal is revenue record.
No.
I want to understand. I don't know. You appreciate.
Yes.
I don't know Dharani portal. I'm asking. Dharani portal is revenue record.
Revenue record.
Is it revenue record?
Yes, my lord.
So you wanted entry in revenue record on the basis of sale deed dated 21/9/91.
No, my entry is already there, but I may make it mere myself clear.
It's based on the prohibition.
Blocking.
So further transactions of sale will not happen. It's agriculture land.
So like if it is blocked, if it is like not blocked. No, what we are asking, trying to understand. Supposing if your petition is granted and not blocked.
Yes, madam.
What is the effect?
The effect is I can.
You can sell.
No, here my difficulty is not for sale of the property. More than that, I am unable to borrow the loan and also
Borrow the loan, there is no provision.
Not granting, so even crop loan also not granting blood.
Mr. Venugopal, it's only blocking registration for further, because in order to prevent further litigation, this is multiple, it will only end up in
I can
multiple litigation. This is the
Your
public.
Lordship may make it clear that I'm entitled to borrow. The difficulty is that I'm not entitled, my lord. By virtue of this, they are not granting right bandhu scheme. I'm not, even if I approach the bank, they are not granting crop loan also. That is the difficulty.
There is no averment to that Raitu Bandhu not being granted because it is based on
No, my
the.
lord.
And those people even before this thing saying value and 100 crores, and these people will fight it out in civil suit after generations. They will get a paper degree without not doing the good. Yes.
Let's.
So what is the ground of challenge? Now we have understood. So first application.
Agreement of sale, my lord, it by itself does not create a right in a favor of the party, my lord.
Agreement for sale.
Yes. On the basis of an agreement of sale.
Doesn't create.
Yes, my lord, section 54.
Yes.
Lordship is well aware.
Yes, yes.
My respect to submission to your Lordship is that in a suit for special performance, the grant of special performance is a discretionary relief. Whether he is entitled or not, that is a not a
Different.
So my respect.
But we can't prejudge that will not grant discretion in his favor. We can't prejudge. Submission, we have clearly understood that agreement for sale does not create any title under section 54, correct?
Therefore,
No dispute with this proposition.
Which suit, my lord, I am not a party to the suit, and the order granted by the learned trial court judge is not binding on the registering authority. That is only against the person whom an order is granted. Against the defendant is the not to alienate order is binding, not on the registering authority. That is, these are my submission to your lordship.
That's it.
Yes.
This intra-court appeal is marked the presence. This intra-court appeal is filed against an order dated 30th day of June 30th June 2023, passed by learned single judge, by which writ petition preferred by the appellant stroke petitioner has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that what was that agreement, Mr.?
Agreement of sale. That is not the that agreement.
All right. Facts giving rise to filing of this appeal briefly stated are who had in whose favor, who is the plaintiff in that suit?
Your lordship, page 33. That is the interim order granted.
33.
On Matangi Kumar.
1/6. That one Matangi Kumar.
Agreement of sale 1811. Page 34. Your lordship kindly consider.
1811.
8/11/2010.
8/11.
He filed suit on
1811.
8/11, my lord.
8/11/2010. 10.
And he files the suit in 2020, my lord.
Facts giving rise to filing of this appeal briefly stated are that delete land measuring land bearing survey number 187 stroke C stroke 1 measuring 6
by availing the bank loans, crop loans. May I request your lordship.
Arey, Mr. 100 crores you will take, those people will fight it out in generations to come. You will disappear. You can please get yourself implemented in this suit.
Please.
In the same day, there will be a indemnity exam if the title is. Yes.
Wait, wait, Raj.
Huh?
This is also a admission
Heard on the question of admission.
slightly on a
This
different.
order. WA 814
814 of
23. Same order, madam. List along with.
Wait, please. The word matter will matter. Seeking direction.
Right. Mr. Rao is very magnanimous. Management and RRI most. Which page, Mr. Rao?
22 or 27.
22. Yes. Same order?
Same.
Yes, madam. Page 24. Same order.
Let's see.
24, 25, 20. Same order. Like see whatever is some date, etc. may change. Representation, etc.
today we
Disposed of. Disposed of.
Certificate copy today.
Certified copy today.
Much of this. May it please your lordship. This matter is filed seeking direction to the respondent to consider my application for
Management quota.
response.
Mr.
Same order, lordship.
Same, which order?
Page 51.
Page?
I have
51?
There is no 51.
No 51.
I have not filed any covered matter.
72 zero, sir. 50.
283, 23836 of 23. You do you have an order? No, similar order.
Yes, my lord.
Then give it what?
Yeah.
This you cannot make pickle out of it, right? It is meant for us. Otherwise, you sign it and give it to Mr. Rao if
I'm
he.
sorry, ma'am.
Mr. Rao, see the order. Give a copy to him. Again, trying to make pickle out of it, right? Don't, I mean, if you distribute the knowledge gurus. Yes. Correct, Mr.
I have submitted a representation dated 26/8/2023, my lord. Representation is at page number 13, my lord.
Yes, we submitted them to secondary representation. You will not release on that.
Repeated disposed of with directions. With directions to the university. To decide.
Consider in this one, the representation page 26.
Dated
26/8/2023.
within 2 days. Mr. So his representation is there 26/8/23. You decide it within 2 days.
Yes, sir.
We are not making any opinion on merits. Disposed of.
I'm deeply obliged.
This is the correction. Here. Disposed of with a direction to to consider and decide the representation dated so and so. Direction to the university. Correct. The difference is that he has already submitted a representation. That's why the change. Here the liberty was there.
My lord.
Sharing is a big virtue. Young man.
Yes, my lord. My
To
lord,
share something with everybody is a big virtue. So learn to share. Learn to share with Mr. Rao, with court,
Yes,
the
my-
orders which
yes,
you
my
have
lord.
got.
I learn, my
Even though it belongs to us. Like
My lord, may I seek a direction for copy today?
Already submitted a representative.
Here. Then again here will be changed.
I will do both.
On this. Petitioner.
Representative. And you must be the direct that. Now it has.
This correction. All right. Six, madam.
My lord, sorry, my lord. My lord, I'm sorry, may I seek a direction for copy today, please? I'm obliged. May I please, your lordship?
But sir, I'm appearing for respond number 2 and 3 in this matter.
Okay. Heard on the question of admission, petition is admitted for hearing notice. When IA dispense with you is allowed, right? This requirement of filing whatever is dispensed with, in the result IA is allowed. Heard on the question of admission, petition is admitted for hearing. Next.
My lord.
Mr. Rao, yes.
Geo 72, lord. Geo 72, my lord. Lots of similar.
Same order, right?
Same order.
Which page, Mr. Rao?
Starts with page 51, lord. Operator portion, my lord, 61, lord.
Yes. What is there? The order was passed in no. We only said that 20 conversation will be impacted. That is, we only said that matrix will be.
Against this order, the SLP is pending before the
Yes,
order.
yes.
You have got notice?
No, no, I did not. No, I just seen, my lord, live and law, my lord.
Live law.
Live law.
So, Mr. Rao,
My lord.
we should
No,
permit
no,
him.
the thermal law, my lord. Thermal law.
No. So therefore, Mr. Tirumal Rao is already gone. So he should also go, Mr.
My lord.
Lighter vein, Mr.
Yes.
You understand. Which page, Mr. Rao?
No, page, starts page 51, 61, lords. Operator portion 61.
What is this? Integration.
Triple one is not the page.
Lordships.
Which page?
In this 100% reservation matter, we passed some order, no? Saying it is
So
20 colleges permitted, 39 colleges.
Yes, yes. That order. That page 61, lords. Operator portion 61.
61. You
I
are
request,
looking
my
at some
I'm
other,
having, my lord.
you are looking at some
Give
other.
Mr. Rao.
Yes, my lord.
Be kind to the court.
Yes.
Save time.
My lord, I am
You don't want us to sit till 5 o'clock, right, Mr. Rao? Do it. And these orders passed by us only.
sorry, 94.
They should keep it, but our staff doesn't keep these orders. Madam, all you should have this orders in a flap and write down 100% and this thing reservation. See how time is wasted. Supposing if Mr. Rao has not given. Learned counsel for the petitioner submits that writ petition involving similar issue has been entertained and an ad interim order has been granted. In support of aforesaid submission, reliance has been placed on an order dated 29/8/2023 passed by this court in WP 23734 bar 2023. Paragraph. Then this order, everything, right? Notice, etc. Issue notice from this. All this is right. List on 6th of September 2020.
Item 10 also.
Mr. Rao, 10 also?
10 also, my lord, but it is nothing.
No, no. 10 also interim order list on 6 September. And which other case? That's it. All right, that's it. All. Yes. Madam. Now 9. We will have to ask Mr. Rao where is he? In between Hyderabad and Delhi. We know, yesterday I asked him to appeal. This is what you should do, madam. Every case similar order, take a printout, keep it in the file, or keep a note, this thing, like folder. We have copies. This is the order which we passed. So, Mr. Mayur Reddy, learned senior counsel, everybody is marked present with consent of parties, matters heard finally. Then this is the order, madam, para 3 onwards.
But within 1 week, they have to.
1 week, 1 week. They have to furnish residence.
Upon furnishing, Lord, we will treat them as a local kind.
Yes, that's the order. It is item 9.
No, this is item 9.
Right. 11. Mr.
Copy today, man.
Management quota.
Yes, Lord. Right. I am ordering item 4 last. Just before now.
Madam, item order in item 4, same order.
Same order in item number 11.
Same in 11 disposed of, right? Any confusion, please ask once.
Mr. Prabhakar, is there a representation in this case as in item 4? There was a representation. There was a representation submitted. In this case also there is a representation? No. Because one matter there is a representation dated 26/8.
In this case, there is no.
So the order,
So in the
original order of 4 will be followed.
Madam, item 4 order. In case he has not submitted a representation. So original order in item number 4 that he submits that he be granted liberty to submit a representation, and in case such a representation submitted, university shall decide the same within a period of 2 days from receipt of representation, and everything else is same, right? The only thing we are trying to tell you is that he has not submitted a representation.
In that case,
Item number 4 also not submitted representation, here also not submitted. Item number 4, same order then.
Page 22 to 27.
22 to 27. Page item 4, 22 to 27 is the format, type that order. Certified copy today. Yes. 13.
My lord's kind permission.
13.
It's only registration, management quota registration.
Same order matter.
11 also, Lordship, for the registration of management quota.
No, this is 11,239. Madam, which case have you called?
13.
What happened to 11?
11 we just.
Item number 11, Lordship.
You have broken up later.
Similar to item 4.
It has been disposed of.
Yes.
Busy talking to friends, right? So this the case. Mr. Rao knows, you ask him.
13, 14 also, my lord, the PNC registration, management registration. But they have to.
13, 14. They have to submit a representation.
Only 13. 14 is a public hearing.
13 and 15.
13 and 15.
14 is different, my lord. 13 and
14 is different.
13 and 15. Sorry, my lord.
Mr. Rao stood up immediately. You said 14. He said, what my EIA notice I am challenging, and Mr. Rao is getting it disposed of.
Yes, my lord. Yes, my lord.
So 13 and 15. Representation in case he submits.
Yes.
Same. If you have any difficulty, please ask me. 13, 15, disposed of, madam. 2 days, you submit a representation, 2 days they will decide. That's the similar order in all cases we have passed.
My lord, may I please, my lord? My lord,
What is the
petitioners before lordship, my lord, questioning the notice issued by the ninth respondent. My lord, what is the purport of the notice, my lord? Now, pursuant
page?
my lord, 31, my lord, 3 notices, my lord, issued by the ninth respondent directed to, my lord, they are proposing to conduct the public hearing, my lord, tomorrow. My lord, one day, my lord, my humble submission before this honorable court, my lord, they are going to conduct the public hearing in 3 places, morning 10:30 and 12:30, 3:30. My lord, my endeavor, my lord, even one day may not sufficient for conducting the public hearing. But, in a high wash manner, my lord, they
Appearing for the pollution control board, my lord.
Mr. Please, will you please sit down, Mr. Council? Sit down.
My lord, appearing for the pollution control board, my lord. My lord, in fact, the hearing is happening in only one location, my lord.
You have come out with timetable?
My lord, yes, my lord, I've already written to them, my lord. They are coming back with the necessary instructions.
You
My lord,
tell,
we'll update
tell
you.
that we have to produce it before the court.
Yes, my lord.
And
Yes, my lord.
non-compliance will be treated as
Yes, my lord.
contempt.
No, my lord, we will produce it, my lord.
Then why you are hearing eyewash, right?
My lord. With
You,
respect,
Mr. You should have, on receipt of a copy, you should have sought instructions and said that we have rescheduled the hearing. Oh, now only one hearing you have it, other hearing some other day.
no, my lord. My lord, it's like this, my lord. With respect to the conduct of the public hearing, it's pertaining to the same industry. And it's pertaining to the same industry, my lord. And in fact, it's happening only on one place, my lord. We have the necessary images with respect to that.
He said 3 places.
No, my lord. No. My lord. Only one place, my lord. Different times.
Mr.
Which is
Na-
also permitted by
I'm sorry, my lord, I'm sorry, my lord. Even same 10th respondent, who is the private company.
hearing. It's
my lord,
pertaining to the
they
same
conduct-
industry.
they conduct
And
the
it's
public
pertaining to the
hearing
same industry, my lord. And in fact, it's happening only on one place, my lord. We have the necessary images with
different
respect to
places
that.
around
Three
the
places.
5-6
No, my
kilometers distance.
Only one place, my lord.
Different
Different
villages,
times.
right?
It's
Last
also
hearing is
permitted
taking place where?
I'm sorry, my lord, I'm sorry, my lord.
I'll see, my
Even
lord,
same
I filed the
10th
three
respondent,
notices.
who is the private
Hearing,
company.
my lord,
My lord,
it's pertaining to the same industry.
No,
33
And
even
it's
30
pertaining to the same industry, my lord. And in fact, it's happening only on one place, my lord. We have the necessary images with
different
respect to
places
that.
around the
places.
5-6
No, my lord.
kilometers distance.
Some
Only
village.
one place, my lord.
Different
Different
villages.
times.
Last
Also
hearing is
permitted
taking
by-
place where?
I'm sorry, my lord, I'm sorry, my lord. Even same respondent, who is the private company.
No, my lord.
My lord, 33
The same industry.
No, 33
And
even 30
it's pertaining to the same industry, my lord. And in fact, it's happening only on one place, my lord. We have the necessary images with
different
respect to
places
that.
around the
places.
5-6 kilometers distance.
Some
Only one place, my lord.
One minute. So then second hearing is
12:30.
where?
In same village, Miller, Chautapalli. Kindly see page number 31.
Page 31 second.
Chautapalli. Then third
32.
So 3 p.m. my lord.
Third is the 3 p.m.
this notice is dated what, Mr.?
27/7/23, my lord.
27/7/20.
7/23.
1 month ago. All right. So your grievance is that only one place it should be held, not one place.
One day, Millard, one place must be Millard conducted the public hearing. Apart from that,
What this thing EIA notification dated 14/9/2006, what does it provide?
Millard, EIA Millard,
Governed by 14/9/2006, right?
Yes, yes.
What is the provision?
Millard,
14/9/2006.
even Millard, my Millard petition before lordship unable to get, Millard, environment impact assessment, Millard, even according to not only Millard, the petitioner's grievance before.
No, this is in respect of what this thing environmental, who has applied to R10 has applied.
R10. R10. Millard, explain.
1 minute. Applied for environmental clearance.
Yes.
What is this industry?
Cement, Millard.
Cement.
Cement, but according to their Millard, even despite they given the Millard project report, only they stated Millard, we are having the 400 acres. They did not.
So these petitioners are villagers of this
Melcheru, they are the adjacent landowners.
Environmental
They are
clearance.
the affected
What
parties.
is this industry?
They filed cement millets.
So this cement industry is set up
Cement
on a land
according to their
adjacent to
millet,
your
even
land.
yes, despite they given the millet project report. I filed the millet, we are having the 400 acres. They did not.
No, so these petitioners are villagers of this.
Now, Melcheru millet, there is the adjacent landowners.
Environmental clearance.
Was affected by
What is this industry?
they filed cement millet.
So this cement industry is set up
Cement
on a land
according to their
adjacent
millet,
to your
even
land.
yes, despite they given the millet project report. I filed the millet, we are having the 400 acres. They did not.
So these petitioners are villagers of this.
Now, Melcheru millet, there is the adjacent landowners.
Environmental clearance.
Was affected by
What is this industry?
cement millet.
So this cement industry is set up on a land
According to their millet, even yes, despite they given the millet project report. I filed the millet, we are having the 400 acres. They did not.
Now are villagers of this.
Now, Melcheru millet, there is the adjacent landowners. Was affected by
Industry is set up on a land
despite they given the millet project report. I filed the millet, we are having the 400 acres. They did not.
Now are villagers of this.
Now, Melcheru millet, there is the adjacent landowners. Was affected by
Industry is set up on a land
despite they given the millet project report. I filed the millet, we are having the 400 acres. They did not.
Now are villagers of this.
Now, Melcheru millet, there is the adjacent landowners.
Industry is set up on a land
Despite they given the millet project report. I filed the millet, we are having the 400 acres. They did not.
Now are villagers of this.
Now, Melcheru millet, there is the adjacent landowners.
Now policy. Since you are defending pollution control board, we are giving you some of the compliments. Pollution control board officers sleep on the complaints and they are like they are in competition with government as to who is the biggest litigant before the high court, whether government or pollution control board. They are competing with you. Don't take it lightly. See, even you are defending pollution control board, we are giving you some of the compliments. People approach. Pollution control board officers sleep for people to check the complaints and they are help people like So, but they are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Conduct. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. People approach. Pollution control board also say for people to check the complaints, and they are people like. So, but they are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are people like. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board also say for people to check the complaints, and they are like control board. They are in competition with government people approach as to who is the biggest litigant before the High Court, whether government or pollution control board. They are competing with you. Don't take it like any complaint you make. You are defending pollution control board. We are giving you some of the agreements. Pollution control board We have given the name that how many members means whosoever attends. We cannot force them.
No,
If they say that only one villager attended, we will be alarmed. You tell us how many, you make a video and tell us. We will ask them to.
yes,
Fine.
kindly ask.
Yes. Yes, madam, what have you written now? See, mutual discussion always a solution.
Sort out the
Sort it out, all problems sorted out. We are trying to do that.
obligation.
That we will deal with. The notice has been issued, they will file counter, then we will decide what happens.
Yes.
Yes. You will, public hearing, videography,
Yes, madam.
public service.
Yes, madam. Yes, madam. It is being undertaken. Madam.
Correct.
Then
Full stop, it is, yes. It is further submitted, not pollution control held.
that the pollution control board did public hearings in different types, only to ensure that the public does not participate in the public hearing.
It is also submitted, that that environmental clearances sought for by respondent number 10 pertain to increase in production capacity of cement and clinker, in enhancement of production capacity of limestone and amalgamation of mining leases granted to respondent number 4. Therefore, the same cannot be treated as different projects, and the provisions of and the office memorandum dated 19th April 2010 issued by Ministry of Environment and Forests has no application to the fact situation of the case. Paragraph on the other hand, Learned Counsel for the Pollution Control Board submitted that the hearing shall be conducted in such a manner as may be directed by this court. It is also submitted that the proceeding of the public hearings shall be videographed by the Pollution Control Board and shall be produced before this court. Paragraph. In view of aforesaid submissions. No, paragraph, we have considered the rival submissions made on both sides. We'll stop the applications, three applications seeking environment clearance have been filed by respondent number 10 in respect of production, enhancement of production of cement and production capacity of cement and clinker, comma, enhancement of production capacity of limestone and amalgamation of mining leases granted to respond number 4. Full stop. Therefore, it is evident that these three applications submitted by respondent number 10 seeking environment clearance cannot be treated to be three different projects. Full stop. Therefore, in our opinion, the office memorandum dated 19th of April 2010 issued by Ministry of Environment and Forest has no application to the present case insofar as it pertains. And issued by Ministry of Environment and so, delete thereafter. Ministry of Environment and Forest, Government of India, comma, insofar as it prescribes holding of separate public hearings does not apply to the fact situation of the case. It is full stop. The notices have been issued to the villagers 1 month back on 27/7/2023, and all the villagers have the notice that the public hearing will take place on at 10:30 a.m. 12:30 10:30 a.m. 12:30 a.m. and 3 p.m. to stop. Since therefore paragraph there as the villagers have already advanced notice about date of hearing, therefore we direct that the pollution control board shall shall commence the public hearing at 10:30 a.m. and shall continue with the second public hearing in pursuance of second and third notices as well after conclusion of the first hearing. After conclusion of the first hearing till all the public hearings are concluded. To stop, the aforesaid direction is being given for the convenience of the public who may participate in the public meeting, and since the public meeting has to be held at one place only in the village. Full stop. As the use right as the public delete this sentence. Last sentence. What? Delete. As the meeting has to take place only at one place, therefore the direction is being given to conclude the public hearing with regard to all three environmental clearances one after the other, bearing in mind the convenience of public in general who
10:30, not 1, 10:30.
10:30.
Obliged.
We said 1 o'clock probably, I said 10:30.
And pollution control board, not public service. Commission.
We said Public Service Commission. Huh?
Pollution control.
Pollution Control Board. Huh?
Your Lordship, may I
Which
request
is
a copy today?
which is a pro people body. You are, no?
Yes. May I request a copy today, my
Not
lord?
copy to them.
Obliged, madam. Obliged.
Do it, mister. What is this?
Yes,
Everything copy to.
Inform them.
You can't inform them, then nobody will listen to you.
No, my lord, I will inform, my
If
lord.
they don't listen, say that I will not represent Public Service Commission and Pollution Control Board also.
I will inform, madam. I will. Obliged, madam.
If your client doesn't listen to you, then it's the right time to give up the brief and to hand over to senior counsel.
Obliged.
Obliged.
Please, Lord. My please not.
Speaking of the
Repeat.
admitted for hearing issue notice.
Lord, maybe permitted to take out personal notices against R5 and R5, R5 and R6.
Notice will go.
Respondent, our lordship.
So they are unofficial respondents. I'll
Madam, personal notice to R4.
R5 and R6.
No, you take a personal notice to everyone then. Personal notice and proof of service. Admitted for hearing. Yes. Mr. Prabhakar,
Fact is your lordships.
counsel for the petitioner heard on the question of admission.
Lordship.
Petition is admitted for hearing, issue notice.
Worships, if they would be started the program to implement the millard, then petition would infructuous.
No infructuous. Issue notice on IA 1 of 23 as well. Let them file counter.
Obliged.
Nothing, everything is sub judice.
Deeply.
Notice. Heard on the question. Regularization of occupied government lands. Notice. Admit notice. Record perused. Admit notice.
One second.
Yes, sir.
Right.
Please, my lord. 19.
But then you.
I submitted a brief synopsis
Ah.
on a matter. And
19.
filed an
You have filed an application.
additional affidavit, my lord.
Amendment you wanted to file?
Additional affidavit, my lord, showing the previous antecedents of the petitioner before your lordship.
No, but it must be part of your petition, right?
Yeah, we filed an additional affidavit in the PIL.
Last date we had given you time to amend.
Yes, my lord. After that, my lord, we.
You are the person under the sun, right? Everything, everybody under the sun, right?
You're-
Same government
Yes.
under the, no.
In the world.
Very peculiar.
Well,
This
that was
amusing,
little-
nothing to do.
Literal translation from Telugu to English.
1 minute.
In fact, my lord, your lordship's order, which my lord's passed in WP.
No, welfare of all living beings on earth.
That was a translation from Telugu to English, man. That's why.
But-
My lord,
No,
in fact, the order. which
lighter
lord-
vein, Mr. Lighter vein we are saying, because
yes.
some things are so striking that when you read, you always remember. So like, we remember still that this thing.
Grateful, man. My lord,
Living
your lordship's order, which
of all living beings on earth.
my lord, the order which your lordships had passed in PIL SR 29108 of 2023, there, my lords, your lordship had discussed all the judgments relating to PILs and the jurisprudence with respect to PIL, the previous order. In fact, I have a copy of that.
Which order?
Yes, I just asked.
PIL.
The previous PIL, my lord, where your lordships had
Yes.
one. In Balwant Singh Chowpal also. my lord.
Yes.
And in that case, your lordship, the facts were that the petitioner in that case was seeking to cancel some sale deeds. Your lordships have, while discussing all the PIL jurisprudence, have said personal agenda, personal grudges cannot be gone into in the question of PIL.
What is, who are you then?
In this matter, my lord, we have no direct personal connection to the government order. If I may only submit, my lord, the government order, which is now impugned before your lordships, seeks to regularize sale or transfer document, does not even say sale deeds, documents which are executed on notarized paper, by exempting them from paying stamp duty, registration fees, and only on the basis of some documents which are mentioned in the GO, my lord, impugned GO. They say that title can be transferred by the collector, and the idea behind the GO is apparently to reduce litigation. Our submission, my lord, this is in fact going to cause further litigation. Your lordship will see page 16.
We quite see the point which you are making,
My
right?
lord,
Your
yes.
valid point.
Yes, my lord.
But can you not maintain this petition as an aggrieved person? Or the only this thing PIL means who are you then again?
Yes, my lord. The writ petition would be
So
writ petition would be, my lord. I've stated that also in the additional affidavit.
this brief synopsis.
Brief synopsis, my lord. Yes, and
No. We want to. Where have you additional
in
affidavit?
the additional affidavit, my lord, we have
Where
said
have you filed?
it's IA number 1, my lord. It's numbered also. So, IA.
Running index. Yes.
To show the antecedents of the petitioner before your lordship.
What is it?
Yes, my lord.
Which para?
Page 4, para 5, your lordship will see.
Page 4. Public spirited.
And para 6, we have said what previous services he has done and what he is doing currently. Para 10, 11 and 13, we have
Heard on the question of admission, peruse the additional affidavit filed on behalf of the petitioner.
there's an urgency also.
1 second. Registry is directed to number the public interest litigation. Heard on.
Second
and
is-
she appears for 3.
Count.
Either you don't want to file counter, we are not recording.
I'm taking
We are
notice.
saying that it's illegal.
I'm not taking notice. Not.
So this is also invitation. That will you file counter? It's not our case, madam.
Alerts have already.
Please appreciate Mr. GP. We have issued notice.
Yes.
If you don't
Alerts have already dictated. Alert so that alert I.
dictated means dictated is submissions for our reference.
Alerts at
That
four.
what is the contention? What dictation?
My apologies. Alerts at
Notice,
four.
we have said notice, you said I appear for 2. Then we asked her, when she said 3, then you don't say anything. We have recorded your presence, madam. Let them do whatever.
4 weeks counter.
Next case, we will not tolerate this, mister.
Yes.
Enough. And you are sufficiently senior at the bar to understand. She may be a junior counsel, but you understand.
My apologies.
But if she is a government advocate, she must have put in 7 years of practice, correct?
Yes.
She doesn't get it. Tell her
Right.
during T session counseling
Alex.
that merely standing up and looking at the court doesn't help.
My apologies.
We will record this order sheet that stood up and looking at the court.
Alerts.
They were at the first instance, they were not saying anything. So this is what, when we have given exercise to our vocal cord, then this is the outcome. When it will expire?
It's only geo guidelines will not have to be formulated.
The GO specifically says only on the basis of the documents which are listed above, the registering authority shall accept these documents as valid.
Same
For the term.
Counter within 4 weeks, may file if so advised. Though counsel
file.
for respondents have stood up and have not said anything, yet in the interest of justice, this court on its own is granting 2 weeks time to, you have filed some interim relief also.
Yes.
On its own grants so and so time for filing a counter to interim relief. List on to after 2 weeks for consideration of prayer for interim relief on fourteen 9/23 for consideration of prayer for interim relief.
Grateful much. Too short. Alert. I request 1 more week.
This is only on.
Interim relief.
24th.
If you can't, we will stay. Yes. Well, this is illegal. You understand, it is per se illegal, you probably cannot defend. That's why she is not saying anything.
Guidelines are yet
She-
formulated.
No. That's why she is not saying anything, because she knows that it can't be defended in law. Yes, madam, yes.
Right, my lord.
Yes. How can they be?
Lot the SLP has not been listed there.
Yes, that's why it has to be speed. What SLP happened?
SLP has been pending, not yet listed, my lord.
Then
Not may grant-
Learned Counsel for the parties jointly state that no order has been passed in SLPC number 6452/2023. No order has been passed in view of aforesaid no. Learned Counsel for the parties jointly pray for adjournment hearing in view of aforesaid submission. Hearing is deferred.
Your lordship, please, your lordship.
Yeah.
Your lordship, please, your lordship. This matter, your lordship, in compliance to the orders of this honorable court, we are submitting the sealed record, your lordship.
Sealed it? No.
Your lordship directed us to produce the record in a sealed cover.
Notification. Yes, please see. Okay.
This is IAM. Ma'am.
Let's see whether.
I'm on that. Mm. SR number.
So the record is with the not the connected.
She said it's pending in a bit. No, but the record is produced.
Even there is nothing in this record except saying that this entire record is submitted in connected rate petition WP number 6347 of 2023. And this particular register looks very fresh from the shop and single handwriting for all the days. This is the record. This is the second time.
No, you,
I had
you
come
should,
down heavily.
the person who has written this should be, like, who is this person? Find out. Same handwriting, same ink. Just like at a one go, you and fresh record.
We'll find out, Your Lordship.
Find out, madam, this. Do you think that this record, this register is of 22? Can you make up?
I'll verify.
We will give it to Mr. Praveen Kumar. That's right.
Say it.
Doesn't contain any date.
It is also.
No.
We'll verify it, Your Lordship.
So what you have to see, but this is not a complete record.
It was sent in a sealed cover, Your Lordship. Even we have not.
Madam, give it to Mr. Praveen Kumar. See, Mr. Can you see that this is, please see the new register, right? All handwriting, one by one person, same ink.
Yes.
Not different dates. We prima facie. And can you say that this is a record leading to issuance of gazette notification dated 28/1/2022? That means sometime in the year 21. Serious
We'll
issue,
verify, Your Lordship.
madam, serious issue.
The record is sent in a sealed cover, Your Lordship. Even we have not verified.
We want to teach the person concerned a lesson. This is a serious issue of they don't understand that producing a forced sort of a record before division bench of High Court is serious thing. Mr. Praveen Kumar, show it to her how it is similar and this thing. Madam, see, as an officer of the court, you please tell us. Please see, madam.
Yes.
Please
Yes.
go there.
Yes.
You also go there and please see. what it is. As an officer of the court, can you say, Mr. Prasad, please? This must be 20 prior to 28th of January 22. See the record, the register, see blank, I mean new register, everything. See the ink, same handwriting as if somebody has prepared.
There are no dates, your lordships. No dates, only months and years.
No, no, go to the last page and see the closed, what is the date they have corrected?
Last page, Mr. Prasad.
Closed. 31/5/2022.
Huh?
That is what the case is.
Huh? What is the date? Date. Sit down, Mr.
It is 31/5.
Huh?
31/5.
31/5/2020.
31/12.
Please sit down. He stands, so we can't see him. Huh?
31/12.
So the Gazette notification was issued on 28/1/2022. We don't know what, how the proceeding could continue. Case for a prima facie inquiry. No, we will not record your submission, right?
In this match.
I mean, as an officer of the court, we are asking you.
Officer of the court, I have to answer, but
Ah,
record is something. Record is rewritten now. Something to be looked into.
second. Yes, mark the presence.
In this matter, your lordship,
No,
specially
no,
please
wait.
appear.
No, the record is not complete.
Yes, your lordship.
The order is, madam, dated 4/8/2023.
Yes, your lordship.
You are directed to produce the original record in seal cover. This, you have only produced the register and the contains a note that original record is with it before the High Court. So this is also High Court. Huh? Madam?
Yes, your lordship.
Huh? No, but where did they just say High Court? No, that's the original record in a certification before single record.
This is the record. Production of seized reject notifications. See the program recess.
You get the original record here only, madam.
We'll ask them to produce the original report.
No, this is here in the High Court only before learned single judge.
It's
This is
not a
only.
petition, your lordship, they are saying in the.
So where is that record?
It is with the register judicial, we can ask them.
Registered judicial, right? You should not have done this then. You should have said that the simple thing is that the record is in the custody of registered judicial. He may be directed to produce. Why did you prepare this register? You means whosoever has written. Who has written it? Yes, madam. Mark the presence. This court, by an order dated 4/8/2023, had directed the learned special government supposing if we issue bailable warrant in the evening, you will be at 2:30, you will be mentioning that he has come and
Next week, your lordship.
be reasonable in modern days of communication.
Next week, your lordship.
70 kilometer people, it's like outskirts of Hyderabad, right?
Yes, your lordships. They can come
Huh?
by 2:30.
Nalsar University is 65 kilometers from here.
Next week,
So-
your lordship will file
No,
it.
no. So supposing if I need some information from Nalsar, they will say 2 weeks. Huh? No, tell us. Will anybody in the university be justified in saying that we ask some information from them, will they be justified in saying that 2 weeks?
Next week.
You can, madam, give up this tendency. Give up this tendency of like always being at ease and not doing anything.
Next week, your lordship.
If they are not listening to you, you say so that he can't come, and then we will have other means to ensure that he remains present tomorrow itself.
Yes.
You will see him appearing in magic. We have a magic wand.
Yes.
So he will appear tomorrow at 10:30 before us.
Next week, your lordship, I'll ask them to file an affidavit, your lordship, by the concerned officer.
Your
Yes,
lordship.
madam. Yes, what have you written? On or before next date of hearing. List on next week is what date? Next week.
Your lordships, if I may state something.
Fifth September 23.
Your lordships, if I may state, even the uploading details, your lordships, because our specific contention also has been that the date of the gazette is 28/1/2022 and the upload in,
See,
Yes.
the original record is still not before us.
yes, your lordships, yes. I've also filed the USR.
This, so then that, before that next date of hearing, let the gazette issue register be kept in seal cover again in the custody of Registrar Judicial.
Yes,
Then 4th September.
I'm obliged.
We will
Yes.
see the record on the
Yes,
next date
yes.
and then we proceed further. matter.
Yes, your lordships. I'm deeply obliged, your lordships.
Madam, just give the bundle.
No. Give that file. When the endorsement will make 20 press. So that's supposed to be 28, 22, they can expire to. Initiate this process of the issue. Yes, next.
Obliged, your lordships.
My lord, I am representing G. Venkatesh. And on the last occasion, your lordships are granted interim order and permitted me to take out personal notice. My lord, I have taken out personal notice and also filed proof of service.
They are not appearing. Not served.
So,
Not filed wakalat.
We don't have the proof of service.
Proof of service.
USR number 795.
One second.
95.
Previously filed, yes. Will set aside.
The order of the single judge was only to pass.
Rate petition, right?
No, I am a third party to the writ petition. And my property is sold away.
The order of the single judge was only to pass orders in 631, my lord. They might as well maintain an application objections before the register also, my lord, for refusal of the registration.
My lord, I have filed representation, no doubt about it, but in persons, your lordship may kindly see.
Though, what do you say to his submission made by GP? That we can permit you to file a representation, direct the authority to hear you as well.
My lord, may I bring to your lordship's notice, my lord? My lord, to preempt my orders from this honorable court, my lord, the first respondent, who is the writ petitioner, has already executed a registered sale deed in favor of third parties. I may also bring to his.
No. So in favor of R1, it has already been registered.
In favor.
That's why he has sold it further, right?
R1, in favor of R1, it is not.
No, petitioner. What is the direction? Loka Krishnamurti is not you, right? Loka Krishnamurti is petitioner. Loka Krishnamurti is petitioner.
Yes, my lord.
There is a direction to receive and register document presented by Loka Krishnamurti. So you are saying that after the order was passed by learned single judge, he has already sold. That means this order passed by learned single judge has been acted upon. That's why he has sold.
My lord.
Correct.
Yes.
Then what survives?
File a civil suit, my lord, for.
My lord, your lordship may kindly.
They have to file a civil suit, my lord, as per Satyapal.
My lord, may I just bring to your lordship.
Satyapal Anand.
Yes, my lord. State of Madhya Pradesh.
My lord.
We were part of that division bench in Madhya Pradesh. Satyapal Anand argued before us.
Page number 57, your lordship. On the earlier occasion, my lord.
Ask him what is he is agreed by an order passed by the nursing to register. Now in pursuance of direction issued to the nursing knowledge, it is registered in favor of this Loka Krishnamurti, and he is saying that he has already sold it. Now what can we do? He has filed a civil suit for cancel. Then he is not understanding.
Sure.
Number 51 is saying.
So now since pursuant to the order of the learned single judge, sale deed is registered. 226, we cannot cancel the registered sale deed. What is the remedy? Where you have to go? Civil court.
I will, and I understood. Your lordship may kindly appreciate the conduct of the writ petitioner, page number 57.
No, you will say he's a very bad man, everything. Bad man, Batman, so many things. But ultimately, what will you get the relief? The relief is somewhere else.
And the registration is in consequence of the orders of this honorable court. The orders are tertiary.
1 second, if we set aside the order of the learned single judge, what is the next course of action? You'll have to file a suit for cancellation of the registered sale deed.
Exactly, that is the intention, my lord. Your lordship may kindly see the conduct of the writ petitioner for a while, and I will shut it.
No, we'll
page number
you
57.
see, with our certification, anything will happen. About his conduct, we'll give a conduct certificate that
No,
is a
I
bad.
am not saying.
You are a good man. What will happen? Tell me.
May I just read your lordship's notice to narrative. Page number 56. Same officer who registered the document refused the mutation on the earlier occasion in the year 2006. That is your lordship's.
It can't be same officer. Officer will change. So it is only the seat that will remain.
Yes,
correct. Don't say the same officer. Same officer gives a different indication. It is the same person, but 2006 to 2023, officers would have changed.
Well, I am making this submission with I will be abdicating my responsibility to bring in to your lordship's notice about the earlier proceedings. Page number 57, 58 is the relevant portion. Last paragraph, I may prompt it to read and then I will leave. May I read, my lord? Another interested party in this case, namely Sri M. Ram Reddy, that is father of appellant, son of Chandra Reddy, appeared and deposed that they purchased the suit land to an extent of 312 guntas, which is the subject matter of the petition, from Loka Sitaramulu, and he is in possession of the land. Further, he deposed that a case is in civil court for adjudication pending. Perused the record available on judgment of Honorable High Court of Judicature, Hyderabad. Honorable Court in Second Additional Judge Mahabunagar Appellate Court and Honorable Court District Municipal Sadnagar. All the evidence produced before me reveals that the father of the petitioner, Soka Sitaya Ilyas Sitaraman, has deposited the land long back and he is not in possession and enjoyment of the land. I do not find any reason to grant succession of suit land in survey number 85, 12.19 mutas in favor of the petitioner and issue of the passport. I suppressed all these things, my lord, and apart from that, my lord, he also obtained paternal passports behind me. Challenging that, I filed one more writ petition. He has received notices in that writ petition also. In spite of that, my lord, he filed a writ petition as if nothing has happened and obtained the impugned order. That's all my submission.
SP Anand, what is the citation? So 6/7/23 is the order passed by learned single judge.
Yes, sir.
When he has sold the property R1 to whom? You said to defeat your right, he has already sold. When?
28/7/2020.
So when was this registered in his favor by?
Registration on 28/7. Registration on 28/7/2020.
28/7. In compliance of the order passed by this court, registered on 28/7, that very day he sold. That very day he sold, right? R1 sold the property to someone.
Yes.
So as rightly pointed out by brother, that even if we set aside the order passed by the learned single judge in your appeal, nothing happens because that sale deed executed by him on 28/7/2023 stands, and this court under Article 226 in view of SP Anand has no power to cancel a sale deed.
2016 10 SCC 767.
767. No power to cancel sale deed. Therefore, issue raised is rendered academic. We grant you the liberty to file a civil suit. That we will pass an order subject to SLP. This
I only request minutes that the matter may be remanded to the learned single judge. That because your lordship's prima facie convinced that I am the proper and necessary part. In spite of that, he did not choose to make me. Interim, it reflects in interim.
No. What can be done now when the order has been acted upon?
When a single judge also, what is the?
You file review before single judge.
I may permit to challenge that before the learned single judge.
You can file review to bring subsequent events on record that this is what fraudulently is done. So learned single judge may recall the order saying that it is order obtained by playing fraud is what?
Your lordship may grant it.
So you withdraw, not liberty. Or we dismiss. But we dismiss, then you can't file review. That's the problem.
Your
Will say that in view of subsequent events, learned counsel for the appellant seeks leave to withdraw with the liberty to prosecute review petition. This in
Was to plead and file.
yes, implead and file. Yes.
That's all.
Learned counsel for the petitioner submits that the respondent number one is guilty of suppression of material facts in as much as respondent number one neither disclosed the order dated 8th December 2006 passed in WP number 25200/2006, nor has disclosed the order dated 8/1/2007 passed by Mandal Revenue Admit.
That's, in case of petitioner is that below the table. It was already come
So it's claiming promotion. Petition is admitted for hearing. It's claim for promotion, right?
It's a notional melody has retired already in 2011.
Please file an application for urgent hearing. We'll consider.
Last occasion also will have.
No, we have been making a mistake which we are now correcting. That we feel 2005 matters should be heard on priority basis. Yes.
If you can medical.
Please, Your Lordship, appealing for petition. Matter is coming for the GHMC counter in this matter.
GHMC
has not filed any counter.
Advocate. Where is that person gone? The public service, that pollution control board, right? No, where that is?
He is one of the person for the.
That's there. We told something about one council of pollution control board. Now you have appeared. How many panel, Mr. How many councils pollution control board has? Huh? How many? We are just for only two. The one who appeared yesterday and today. Standing council. You find out we have told something about you additional standing council. Your additional standing council we have told. No, fine. We have told additional standing council something about functioning of pollution control board. Ask from him. And take steps. Who are you? Learned counsel. For respondents 4 to 7 submit that he shall file counter during the course of the day. Reply, if any, on behalf of petitioners be filed within a period of 4 weeks. Petition is a beginning right admitted for hearing. Yes. Immersion. Monday is what?
We filed our.
Monday, 4th September. 4th September.
We filed our reply, my lord, to the sixth respondent.
Fine. List on learned, Mr. Harendra Prasad learned, whatever. Place for short accommodation, list on 4th September 23. Yes. Next, man.
The counter is yet to be filed by the respondents. The hospital grant them some file.
Admitted for hearing. Counter be filed within, if any, be filed within 4 weeks.
Like to represent Lakshmikant in this matter. My lords, last time when the matter came up, your lordships had granted time to the government of Telangana to file a counter.
No.
But I think notice may also have to go to Transco AP, ma'am. Notice may also have to go
one. So you are claiming fixation of seniority after 2 decades?
No, my lords. The rejection order, I knew that was coming. 5/11/2021 is the order of rejection. Page 21. Your lordship saw that last 2021.
Learned senior counsel for the petitioner submits that the claim of the petitioner seeking seniority with effect from
2002.
2000, what date, Mr.?
31st March 2020, 2002. 30th March 2002.
30th March 2002. You were superannuated. We are saying seniority from 30 after superannuation.
It's retirement benefits. That will be only for
No. We are asking you, you are claiming seniority from what date?
On 30th March, I retired on 31st March. A seniority list was prepared 1 day before I retired.
Acha. No, but with what date you are claiming seniority?
Date on which the seniority list was wrongly prepared, that is 30th March 2002.
You are claiming seniority only from 30th March, not any date anterior to. The claim for the petitioner seeking seniority on the post of
Senior Assistant Executive Engineer.
Assistant Executive Engineer,
Additional, I beg your pardon.
Additional Executive Engineer, claiming seniority with effect from Mr.
30th
Seniority with effect from 30th March 2002
2002.
on the post of assistant.
Well, I beg to appeal for the petitioner, my lords. 4 weeks time may be given to file a rejoinder in the matter.
Counter has been filed.
Yes.
Petition is admitted for hearing. Learned counsel for the petitioner praise fund is granted 4 weeks time to enable him to file reply to the counter. Next.
In this matter, 2 weeks time may be granted for filing counter.
Heard on the question of admission, admitted for hearing. Weeks time is granted to file counter. So 31, 32, madam.
One is senior.
32. Which item you are calling? 31. Ah. Ah. No. Counter, nobody wants to, they have not filed. Admitted for hearing counter if any on behalf of respondents be filed within 4 weeks. Ah.
This matter about earlier about
Have you been heard? No. Were you, was he heard before directing closure?
Yes, well, I heard, we filed the report.
Whether they were
Filed the report only after the.
No, have they been heard or not?
Yes, well, we heard. After issuing the notice will not be issued a closure order.
Ah.
File reply.
Closure notice, no. Closure notice, this is closed. Under which act you have passed this order?
Production closed, my lord.
Water, my lord.
Can both be done together? You deliberately pass such orders to help the industries so that they can file a writ petition. You know the law laid down by Supreme Court. You know the law laid down by Supreme Court.
Yes, we had after issue.
No, what is it? The law is that against composite order, no appeal can be filed.
Yes,
So you deliberately pass composite order so that petitioners do not file an appeal and come here and Pollution Control Board engages you. Lighter wind, I am saying. Advise them, mister. It is your duty.
Yes,
You are their advisor and relying on you, they have engaged, they have tremendous faith in your capabilities as a counsel.
I'll advise this aspect definitely.
Now, which is the judgment?
Composite.
Which judgment? That against a composite order, no appeal can be filed. Which is the judgment? If you are going to tell them, please tell us also.
Very private.
You don't know.
Present.
Don't know, right? What will you advise? Yes, he appeared in my
Yes, but
So you meet Mr. Vidyasagar, senior counsel, and seek his guidance.
He has referred to one judgment.
Before becoming senior standing and super senior standing counsel, must know the law.
That is the.
Mr. Vidyasagar, you asked him.
Yes, my lord, I'll ask, I'll appear in that matter, my lord.
Before Supreme Court, you appeared, right?
Yes, my lord, they, in their, my lord, they
No,
charged
no,
me.
you appeared before Supreme Court, right?
No, not my lord.
Then-
Vidyasagar appeared matter, my lord, the earlier matters.
So then you should say no, that Mr. Vidyasagar had argued this matter
Yes,
and we had decided it. Our judgment is also there.
I'll request him.
So deliberately you pass such orders so that they are not required to, we cannot relegate them to alternative remedy of appeal, right?
Yes, for 2019 SEC.
Huh? 2019?
2019, my lord, 19 SEC 479. 2019 SEC, 19 part 479.
2019, 19 SSC.
Yes.
Page.
479.
Good. That's like a standing council. But despite this law, your officer's authority has deliberately 33A and 31A of the Air Act. You should be obliged to them, Mr.
In this matter, my lord, by
They don't want you to go to file an appeal and straightway come to, because they have performing their task of generating litigation for the High Court.
in this matter, my
So
lord,
they do it by two ways. One is by not taking action on the complaints. Another one is by this passing combined orders of anything against anybody, so that you are not required to go to appeal, file an appeal and directly come to High Court. These two novel ways of generating litigation for the High Court. That's what we have told your junior standing counsel since yesterday. Mr. Standing Counsel, we want to tell you, take this opportunity. Most of the cases petition come here and say that we have made a representation, Pollution Control Board is not taking any action. What we have suggested is that you should come up with a timeline, that if a complaint is received, 30 days the action will be initiated. If it is not initiated, the concerned officer will deem to have forfeited his right to receive salary. And the non-compliance on your order only, right, should be treated as contempt of the court.
I'll admit.
Come up with this. You are meant for people, not anti-people activity. Correct?
The order is not enclosed. To your report, there is no order for us to look at what are the reasons given, nothing.
Report 5.
That is impugned in the petition.
The petitioner unit is not carrying any activities in this.
P1.
Or what they inspected.
Order is P1, right?
Yes. This order passed under the Air and Water Act.
You can't pass a combined order, both under water and air. That is the law laid down by the Honorable Supreme Court. It need to be separate.
Yes.
And you have passed an order
And
and
it's set in Water and Air Act.
That's what we are telling you, Mr. Counsel. The officers pass deliberately these orders under both Act and contributing for generation of litigation for this court. Because see, if a combined order is passed, this Honorable Supreme Court in 2019, 19 SCC 479 has held no appeal lies. We have to entertain writ petition. The result is that you are not required to go to Chennai. The result is you, sitting Hyderabad, you get a brief and file a status report. Lighter when we are saying, at least you can smile, Mr. It's all lighter when. Nothing for part of the order. Correct? Hence, we are trying to iron out the creases in your functioning, advising you which we shouldn't do. And we should impose on you for passing such an order and set aside. So where is consent for operation, Mr. Consent for establishment and consent for operation. Where is it?
Operation is both, my lord.
Where is that? No, we are asking you. You said, Mister, where is the notice given to him? Status report does not say.
What is that page 1, 2, 3?
Where is legal hearing? And what is the record of legal hearing and what is the record of illegal hearing? Para 3 you have said, right?
Yes.
Para 5. 5.
Para 5, which was reviewed in the net.
So you have conduct two type of hearing. One is legal hearing, one is illegal hearing. So in case of petition, it was legal hearing. So where is the record of legal hearing that it was heard, he was heard, and this is the only issue that he has not been heard?
Yes, before the task force met up.
No, this is not, Mr. This is not supported by affidavit, anything. You are not saying that he was heard.
The task force went at 17, the representative of the industry and outlet have attended the hearing. The petitioner industry informed the committee that they are carrying only with.
This is not attending the hearing is not. You have to give notice. You have to tell supply the material adverse to the petitioner and to take action. This is not legal hearing. Then you will ask him to attend illegal hearing. He will be afraid that what illegal hearing, what demands you will make from him. Illegal hearing. What is it? You are a quasi judicial authority. What are the requirements of taking an action against a person? Tell us, Mr. Standing Counsel, tell us. Are you not required to give a notice to the person? Are you not required to supply material to him? There is a stay operating. You are happy. There is a stay.
Expected made, but the industry is running there. No business is
No.
carrying.
Counter affidavit you have not filed. You tell despite opportunity being given, you have not filed. No, this is not supported. This doesn't fit in. Who will appear before us to explain that despite opportunity being granted, why counter affidavit is not filed and only a report which is not owned by anyone including you has been filed. Your signature does not appear. You are an officer of the court assisting this court. Your signature doesn't appear in document and you can safely skip by saying that I don't know, sir, who has filed it.
It's a clear council file, but not a file counter affidavit.
There is a stay. You issue them a notice and hear and conclude proceeding within 15 days. There is no point in keeping this petition pending and permitting them to operate. There is a stay operating, Mr. And you convey with all seriousness. Otherwise, this is not the case. But in some case, we will pass strictures against you. Right? That despite opportunity being given to file a counter affidavit, you don't file a counter affidavit. You file this thing environmental engineer not supported by an affidavit. This cannot be recognized.
File will not.
No, don't file. You want to see, Mr. You want to help the petitioner by seeking time. 2nd August 23, we granted you time to file counter affidavit. You didn't file. There is no material on record to show that you gave notice. The stay is operating. Our conscience does not permit a person who doesn't have CFE consent for establishment and everything to pollute the atmosphere. You have forgotten your duty. We would have something written very nice about you, but not this time, and putting you to notice. We will write to the government to this thing supersede you.
I instruct
And appoint our officer who will perform the functions of pollution control board, because you can't function crumbling under your own weight, contributing to the litigation of the High Court. In this writ petition, the petitioner has assailed the validity of the mark their presence with consent of the parties. The matter is heard finally. Mr. Understand, counsel? What understood? That we are quashing the order You will issue notice to them and hear them, and next 3 weeks you will pass an order and file a order before this court, failing which it will be treated as contempt. It will be reported, though petition is being dismissed, it will come up on a date. And on that day, be ready for action if you don't take action against him. In this writ petition, the petitioner has assailed the validity of the order dated 15/11/2022 passed by Joint Chief Environmental Engineer, Telangana State Pollution Control Board, Hyderabad, passed in exercise of powers under Section 33A of the Water Prevention of So and So Act, right? Counter.
Your Lordship, I seek the time. Your Lordship, I grant the time of 2 weeks.
Petition is admitted for hearing. 2 weeks time is granted to file rejoinder, to file counter.
Counter is already filed by.
You want to file reply?
No, my lord. I'm ready with the.
All right, so petition is, pleadings in the case are complete, petition is admitted for hearing. File, you want early hearing, file an application. That's the rule.
I request time for counter, my lord, 2 weeks.
Admitted for hearing, 4 weeks time. Granted to file counter.
Please, my lords. Because in this matter, my lords, I filed a application for vacating the my lords interim order. That's my apologies, my lords. Sought time on the
No,
last
you have been repeatedly seeking adjournment.
My apologies, my lords. I have prepared a brief synopsis.
We will take it up after the break.
Very well.
Ah. Then,
No. You have not seen the list? Note at the end. No, at the end of the motion list. All passovers will be taken up at the end of the motion list.
yes, at the end of the list, not 2:30. But you don't want it today. Ah. You are pressing, right? That's why we are telling him that he is seeking adjournment on your behalf. Otherwise, he will feel that we own the tank and we don't want this thing.
At the end of the.
It will take some time. That's why remaining things we can do it, right? You are saying, no, they have conducted, they have to be punished for committing contempt also. So, yes.
So matter pertains to the minimum wages, my lord.
Very important.
16 years above.
Notice has been issued, we remember. 37 scheduled employment, 73 scheduled employment, minimum wages not being paid.
Yes.
Admitted for hearing, counter if any on behalf of.
I filed the reply also, my lord.
Admitted for hearing.
Lordship, sir, ma'am.
Please file.
No,
Early hearing. Pleadings in the case are complete. Petition is admitted for hearing. Please file an application, Mr. Prabhakar. We will consider. We know that 73 scheduled employment.
Yes.
Petitioners, the workers are not being paid minimum wages.
Yes.
We know that.
Because in the welfare state, my lord, 16 years back, revised, my lord, in fact, each 2 years and 5 years have to be an ancillary.
We understand.
Yes, deeply.
Your Lordship, I am previous agenda.
For counter.
Counter is awaited.
I'm for the petitioner, Lordship. I'm for the petitioner, the 36th.
We are not saying you are not for the petitioner. They have to file counter admitted for hearing.
One small submission.
On behalf of, this is public interest litigation, not a personal interest litigation.
Previously, Your Lordship stated that it comes under HMDA limits. I'm submitting this preliminary notification which was.
Let them file counter, you place on record. This is no way of submitting. We are submitting cause list to you. We are submitting cause list to you. No way, file it. There is a place for filing, file it.
Yes, Lordship.
Let them file counter, it can't be decided. If we decide it today, the order will be set aside in Supreme Court in no time. File it in the counter. Next, madam.
But in this matter, your lordship wanted the honorable bench to be apprised of what is happening.
Yes, state what happened.
The evidence of the complainant has been filed. And the matter is posted on the 8th of September. It will be disposed of expeditious.
When?
8th of September it is posted.
When it will be disposed of? Learned Council for the Telangana State Bar Council submits that the evidence of the complainant has been recorded. Shall be concluded in view of aforesaid submission.
Lordships are right. But it is respondent number 8.
In view of aforesaid submission, let this writ petition be listed for orders on 12th of December 23. Not 12th, 18 December 23.
I'm obliged.
We expect that on the next date you will tell us it has concluded. This is what we expect.
After your lordship's observation, my lord, the steps for that online thing was attempted.
What's the way?
He was released on bail before.
All right.
I'm
That's-
obliged.
Thank you. Yes.
My lords, I beg to represent Vivek Janman. Pertaining to Insolvency Act for individual persons like petitioners who want to declare themselves as insolvent, My lords are posted for Union of India to reply.
I think IT. Individual, because chapter 3 of IBC.
What is this already 21 appeal petition?
Not being notified. Simply about.
No.
Because this is no IP. Under the provision.
Ah, yes. Yes.
Raj, I am appearing for respondent number 5, Raj.
Respond number 1, Mr. Praveen Kumar. We have understood your grievance. So what to do? He has to respond.
On last occasion also, my lords may see the docket order. They were
Not present. We are seeing that. That's why we are asking. His name appears.
Yes, my lords.
He just went outside, not informed.
Mr. G. Praveen Kumar, learned DSGI. So, press.
To that extent.
Interim order is already there.
Yes, were there, my lord.
You are an insolvent, so no bank should take action against you,
I
right?
filed an application for interim extension, my lords. They are expiring tomorrow. IA 1 of 23.
No, Mr. One thing, lighter vein, if you don't have anything, why you be afraid? Nothing can be done against you. They're very great, right? That I am an insolvent person. I have taken money from bank. I am an insolvent person, no forum, and nobody should touch me.
But after this,
You tell us why we should not dismiss the writ petition, taking into your conduct, because this is extraordinary discretionary jurisdiction.
Yes, my lords.
So no forum, file a suit seeking an injunction.
I have filed a
that nobody should enter my house and nobody should touch me. This is not the thing. We can dismiss your petition saying that we don't appreciate your conduct of misappropriating public exchequer and not paying the amount. It's correct, right? No, is it correct? You have taken money from back.
Yes, my lords.
And not paying.
My lords, I have paid. The difficulty is.
On both the first and second respondent, I filed counter.
No, but you know his grievance, right? What is his grievance? That law does not provide a forum for adjudication of this person as an insolvent person.
Yes.
And he is so cautious that he has obtained an interim order and seeking. Provide him a forum, right? So that we don't want to entertain this petition of a person who is not paying the government, the public money.
Section
And living in the society with this thing saying that I am insolvent. Where do you stay?
My lord, the difficulty is as.
No, where do you stay?
My lord, Secunderabad, my lord.
Tenanted premises.
Yes, ma'am.
And the counter, my lord, page number 19, section 7.
Oh, you are a doctor, see. You are a doctor.
Yes, my lords. I repaid 1.5 CR, my lords. As calamities come in.
1.5 CR digested, not paying.
No, even his certificate will have to be cancelled.
This
one more thing, section 78 of the IBC is not being notified. So the central government has to.
Yes, Mr.
My lord, page, my lord,
No, 78 has been notified for individual, section 78 of IBC.
Yes.
Has it been
Chapter 3, Mr. In substance is why chapter 3 of IBC has not been notified. He is surviving on an interim order. He will never want you to notify.
My lords, may I submit one thing? I went before the insolvency small causes court under the old act of 1920. In view of two judgments of the learned single judges of this honorable court, they are not entertaining my application also. My lords, not under the new court. I went under the old court.
That is repealed by IBC.
Yes, my lord is correct. But my lords, till this act comes into force, that will stay in picture, my lords. That is what provision says. Because
where is that? So we will direct you to entertain the application. Which provision says IBC? Which provision? It will be disposed of right away. Correct. IBC, Madam.
IBC?
Which provision, Mr.?
Provisional Insolvency Act 1920.
my lord, section 243.
He is giving Indian Penal Code, IBC,
ABC, insolvent.
insolvency, bankruptcy code. Arey, madam, you don't have small these things. Huh? Only with commentary. Which section?
My lord, section 243, my lords. It says, may I read, my lord? 243, repeal of certain enactments and savings.
1 minute. What?
May I read, my lords?
1 minute.
Sorry.
Which are the judgments of this court?
My lords, and I may be permitted to pass on.
Single bench.
Single bench. Because of that, when I went before the insolvency court, they rejected out the SR stage itself, saying that this petition against banks and corporations is not maintainable because
What does single bench say?
single judge says that under section 8 of that old act, these petitions are not maintainable against the banks. My lords, I will show your lordships the section 8. It is other way around. Your lordship, so please.
It will have to be heard then.
Yes, my lords.
Right. Learned counsel for the petitioners. You find out Mr. Praveen Kumar and everyone, whosoever is appearing. Learned counsel for the petitioner submits that the petitioner had approached the competent court under the Provincial Insolvency Act 1920. However, the petition filed by the petitioner was rejected.
Yes.
When?
My lords, page number 26, my lords.
Not 26, order. Rejected by an order dated
8/12/2021.
8/12/2021 on the in view of the decision of
not in view of the decisions. They said under section 8 it is not maintainable.
In view of the, so that order you have challenged in this petition.
That order I have not challenged, my lord.
Why?
Because, my lord, when I,
So you amend the petition and challenge that order. Then only you are raising something new
no,
orally.
my respectful submission is
You have to challenge that order, Mister. We are granting you liberty to challenge. Order dated so and so by the court under the Provincial Insolvency Act.
Can I make one?
It is further submitted that the aforesaid order is contrary to section 243 of Insolvency Bankruptcy Code 2016. In view, press warrant is granted a week's time to enable him to amend the petition to challenge the said order in this writ petition. Writ petition. Interim order granted on earlier occasion shall continue. That is most important. List on 4/9/23.
May I make one submission, my lords?
You have made the submission. We have accepted it despite that.
Is this, my lords? I went before the TRT under new code. They said it is not yet enforced. Please, we can't entertain. Then I went under 1920 Act before insolvency.
Mister, you wanted to argue just like that.
No, my
that 243, my procedure, this I can approach. We are entitled to examine that. We are examining your contention. But you have to challenge that order. We are permitting you to do so.
Right.
Most important thing of the day that interim order has been continued has been accomplished.
Obligement.
Correct. Amend the petition.
Obligement.
And we are saying that we will examine this issue.
I'm highly obliged.
You can't have any objection to this.
No, my lords. I cannot, my lords.
Yes.
Obligement.
You amend the petition. 4th September. Yes.
So this is teacher service rules, my lord. Vacancy petition filed by the
Additional.
I have already submitted synopsis.
We have filed, my lord. We have filed vacancy petition, my lord, in respect of the
41 and 42. Password 140. Password. Yes. Next.
Both are same.
also 42 it goes to you.
42 also same password. 43.
Fundamental reservation in CC exclusively.
Wait, please, Madam. In this matter, not about to
Admitted for hearing, a very debatable issue, admitted for hearing. Mr. Rao, we'll admit it. What is it?
NCC reservation, my lord, sir, please to post it today for hearing.
Password, you want us to hear it today?
Subject to lordship's convenience.
We'll see. Password. Let's see if it can be heard. Let's see.
Password.
But you don't take more than 10 minutes.
But I have permitted to file a memo. I think it's to an amendment, my lord, I need to satisfy on the legality.
Yes, that's. If you have a good case, you don't take more than 20 minutes. This, of course, this is a presumption, but rebuttable one. Council may take more time in an exceptional case also.
Yes, yes, sir.
All that.
Yeah. I have permitted to file a memo, my lord, along with the middle papers. That's what are in the
See, password, Mr. Praveen Kumar, come in the later half. It's already 1:40. Yes.
Kindly.
47.
47.
Our last great respect, I will permission to represent Megam.
Yes.
She is my colleague.
Ah.
I may be permitted to represent her behalf.
Correct. What?
I challenge it with GIVO.
Ah.
Government issued a GIVO with retrospective effect. In view of the retrospective effect, the selection is going on. If the selection is going, my writ
The counter is awaited, right? You know that.
is always
Right. So then admitted for hearing. Yes. Admitted. Admitted for hearing. You want to file any reply, you may do so. Want early hearing, file an application. We will consider. No data. System generated. We have introduced that. No, Mr. Prabhakar, you know. Everyone knows here.
Yes.
Mr. We have introduced an a system which generates a date automatically. Because everything can't be heard on a motion hearing stage. You will appreciate that. Right now, the precedence is to Mr. Rao and his persons who wants to seek admission in his university. He knows that. Just now you thought the NCC certificates wanted admission in MBBS course. That's the our district. Yes. Yes, please.
Against the
Order in rate
stay has
petition
been
without.
granted. Stay is granted. File. R1 file vacate.
Without hearing. So yes, who appears for respondents?
Contesting respondent is the first respondent.
So the order has been passed without hearing him. How it can be sustained? He has to be heard. Correct?
It's already. Stay is granted last.
No, not stay. We are setting aside the order, allowing the appeal. Go back to the learned single judge. Right? Correct. You are respond number 5 in the petition, right?
I was appellant.
No, the appellant here.
Yes.
You are the appellant here, but
We are asking about writ petition. In a writ petition, he was respondent number 5, right?
Yes.
You are a station house officer. You are a station house officer. Then who is Parigi Masaya?
I am the respondent. I am the appellant is
5. Then who is for the appellant? Nobody. So the order has been passed.
Respondent number 5 is appellant here.
R1. Correct, Mr. That much we understand, right? Supposing if the petition would have been dismissed, why would you file this thing?
no, fifth respond, first respond now.
The first respondent is the writ petitioner.
So has he been
notice
served?
But he had filed a vacate also, not. He had filed a vacate also.
No, she has been served.
He had filed a vacate also.
Also, we will allow your appeal to date, sir. No, don't come. It doesn't, we don't need your presence. We have told you the reason that we will set aside on the ground that no notice was given to you by learned single judge. Don't come. Yes. We will allow the appeal. Get the copy. Mr. Prabhakar will help you in getting it. Yes.
Item 49, Challa Gunaranjan.
Yes. Like to appear for the appellant. That's
Yes.
well, this is also a similar matter, Milord, where the
Similar?
single judge, Milord, has not heard the appellant at the stage of writ petition, and an order was passed at the time of admission itself. Milord,
Final.
yes.
Online application, what happens? Online application for what? Grant of title?
No, Milord, in fact, it's survey. Milord, in fact, the appellant company has been in possession of certain land since 1984, Milord. Now, at two.
No, when they made an online application, when the surveyor comes, you can file your objections.
Milord, in fact, the survey report is also complete now. But Milord, the only reason, Milord, the only issue now that is left for adjudication, Milord, is the observation, Milord, of the learned.
In fact, we've been telling Mr. Srikanth Reddy, learned GP for revenue, that their offline application, they need to make certain amendments, software amendment, so that they can capture. But unfortunately, that is not being done. Everybody comes to this court and files a writ petition, takes a order, offline application, please consider disposal. Both parties come here and both parties get an order.
We'll hear you after the break. The other side is not there.
Milord, in fact, they have filed a vacate already, Milord.
That's why, see, it's 145, that may not, they are justified in not being here. We'll take it up in password room.
pass over numbers item 35 and 36 nuggets.
Wait. Suffering for the petitioner, you alone. The case where yes, you have given a brief synopsis to your law. What synopsis? Respect of this matter, till public interest litigation. No, what? The lordship has directed us. File a synopsis. No, we are not deciding it finally, mister. What is it? What do you think you are doing? This is for admission. We'll admit it. It's a very genuine point. They have to be heard on vacation of stay. Readings are completed, they filed. So we will decide their application for vacation of stay. Not that 23 PIL we are hearing finally. There is already an interim order protecting you. One thing I want to bring to your lordship notice. Even this honorable court has protected my right. They have violated that order. Violated for that contempt is pending. They will go to jail as and when it is decided. This needs adjudication, right? We cannot right away tell them go from here to jail. Requires an adjudication. In respect of the contempt also, they filed counter and pleadings also have been completed in contempt, your lordship. We have to hear sometime. I leave it here. No, see, mister, it has been only 6 weeks ever since I have come. It's so repeatedly coming so many times before us. 9-8, 28-8. So except public tank, there are others also litigants. One submission. The water body. No, you tell us there is an interim order in this PIL. This 1 minute, please understand. Then you can respond. There is this writ petition has been entertained On 17th February, an interim order has been granted in your favor. Thereafter, I am here 6th week. This matter has come up at least thrice before me. So what is so special about this tank? You are going to, after this appeal is allowed, they are sent to jail. You will get patta rights or ownership. What is it?
On submission.
No, we are asking. There is an interim. Besides this, we cannot stand there on the tank and this thing, protect it.
On submission.
Ah.
The year 2018, an order has been given protecting my.
There is an interim order, Mr. There is an interim order protecting you for you have, according to you, the petitioners have 1 minute. Let us, there is an interim order on 17/2/2023. According to you, petitioners, respondents have violated that interim order on 17/2.
Yes.
For that interim, this thing violation, contempt petition is pending. Contempt petition shall be heard. Right now, we have been telling Mr. is up to 30th August. Today, we don't know till next date, whatever is extended is the day for Mr. Rao and the clients who are seeking admission in his course. You will, MBBS, NCC students seeking admission, that bunch is there. There is no urgency in punishing them. He can't, are you saying that they are at flight risk and they will migrate to Honduras and will never be traced?
Only the thing that I want to bring to your lordship is notice is, now they have laid the road by destroying the tank and also in the FTL area. Your lordship are saying that we will hear the matter, then we will consider it and will pass order. Your lordship, if this honorable court.
No. So have you filed an application seeking ad interim direction, mandatory direction to remove the road and to restore FTL? Is there an application? See, you cannot, you cannot force the court to hear everything. This is 23 matter in which stay is granted.
I am not forcing your reform.
No, we are telling you, we are sharing our piece of this thing, that have you filed an application seeking ad interim direction for mandatory direction for removal of the road and whatever, restoring whatever?
I have not filed it.
That
Because it is a public interest litigation. I'll file it.
File it. We will consider. You are here to assist, not to make our life difficult.
I oppose this.
No, Mr. You are this thing, good counsel. Therefore, we are telling you, every case you are here to assist the court, irrespective of the result. If the result is against you, then forum is 1 hour 50 minutes away, right?
If it case is also against us, it is against the public, not against me.
So you are.
Yes, I am there.
Nobody is deciding, Mr. Nobody is deciding it against public.
Yes.
We are not deciding.
Yes.
All we are trying to tell you is that petition has been admitted. There is an interim order. They have violated interim order. Contempt has been filed. It has been entertained. We will hear it. That's all we are saying. Nobody is deciding it against public.
Why I have insisted is already pleadings has completed. That's why I asked your lordship.
All cases, Mr. Pleadings are complete. That doesn't, we wish that you cross the floor soon, and then from there, along with senior counsels, we will tell every item number 1, pleading complete, decide now, dictate judgment. Item number 2, then we will see how many cases you can take up in a day.
Fix any.
What is the fault of the advocate, litigant who is waiting before this court since 2005? Tell me.
Yes. Fix any date, your lordship, for hearing.
I'll no date fix. Petition is admitted for hearing. What about your vacation stay, Mr.?
That's my respect.
Rejected. Tell us what vacation stay.
I pass on the brief notes and the judgment. I'll only say this much. This is
No, you want to this thing. You have already constructed the road and you want vacation of stay. So as to save yourself from contempt. Correct. What is it? What stay you, vacation of stay you want, madam? Mr.
Let's see. This is the third bill. 2 contempt applications have been moved. Whereas in the earlier public interest application.
Mr. 1 minute. Do you know what is the interim order?
Yes.
What is the interim order?
Let's to laying up the road to be in abeyance. If it is in FTL.
You don't know that. 17/2/23 order you don't have?
I have
What is it? See, there's no ground to vacate this order. Hence the area, tank level.
In the meanwhile, following the order of this court so and so, response are directed to fence the area.
69. Yes.
Instead of doing that,
If any encroachment by way of road has been made, the same shall be kept in abeyance till the next date.
No, either we don't have the order or you don't have the order. There can't be, it can't read differently.
17th February.
Surya Karan Reddy is, you are
Yes,
Mr.
madam.
Surya Karan. Huh? The order sheet 17 to 2023 reads like this.
Yes,
There is no this thing, road and discuss. 70 to 23, what is the order?
Yes, in the last line, my lords, if any encroachment by way of road has been made, the same.
So why we did not ask you to read last line. We are in the meanwhile.
Yes, my lords. In the meanwhile, following the order of this court dated 3/1/20.
No, Mr. Amsil, you are sufficiently senior person, right? That's why government has selected you as one of the competent advocates. So if you are reading last line, then tell the court that I am reading last line. We are at the first page and we are telling you all.
I'm sorry.
We don't know. We can't get into your mind and find out that you are reading last line. We are first page in the meanwhile. So we are saying that order doesn't read like.
Yes, my apologies, my lords. I'll read from. In the meanwhile, following the order of this court dated 3/1/22, passed in WP Bill 42 of 2018, respondents are directed to fence the area of full tank level of Kotta Cheruvu, Naya Talab, Nirmal Town completely and ensure that there is no encroachment in the said lake. If any encroachment by way of road has been made, the same shall be kept in abeyance till the next day.
What does this mean according to you?
It has to be fenced and if any. It has to be fenced and if any road is laid, your lordship, that road has to be kept in abeyance.
But abeyance means not to be used by anyone.
Not to lay the road.
No. If the road has been made, it shall be kept in abeyance means, according to our understanding, shall not be used by public.
no ribbon cutting,
No ribbon cutting, no this thing. That from what? Whose fund? MLA fund. MP LAT fund. Nothing, no photograph. So why do you want to cut the ribbon? Because the election is coming.
In the earlier public, this road is in existence within FTL limits for about 60 years, my lords. What we have proposed is only, my lords, strengthening the bond, my lords, by widening of that road. But in the earlier,
have you done it? What is the status
page
of
45, my lords,
Sir, asking you what is the status of the road on 17 to 23?
And there was a road, my lords, in operation, my lords. We have only, my lords, strengthened that bond, my lords.
So when have you strengthened?
The after 11/1 was issued, my lords. For a moment,
when have you strengthened? For that you are facing contempt.
Yes, my lords.
Why? According to you, they have constructed the road after 17 to 23 in violation of the interim order, right, Mr. Reddy?
Yes, sure.
That is the contempt. So what is there to vacate?
Page 45.
Mr.
In the earlier.
1 minute, please understand. You cannot argue that we will not fence the tank and permit it to be encroached. You can't say that. So there is no vacation after 17. Remaining part of vacation of stay is essentially to be dealt with in contempt proceedings. So therefore we cannot vacate the order and render his contempt petition infructuous.
That's my respectful submission. In the earlier public interest, a judicial officer was appointed to conduct a survey. Judicial officer filed his report saying there exists a road, my lords, for the past 60 years. And that apart, my lords.
No. So Mr.
Another public
again we are asking you, we will see, it will be difficult for you to answer these questions because you see, if you argue, then we will have to ask questions. So then those questions are essentially linked to contempt petition. And an order will be passed today. If you insist, it may be in your favor, against you. Please go ahead. So what did you do after 17 to 23? road, first submission is road existed for 60 years. Understood? And that is by judicial officer. Which judicial officer?
By the junior civil judge, my lords, appointed by this honorable court in the contempt proceedings.
Junior civil judge in the report has submitted.
Yes, my lords, page 45.
All. Then what have you, road
There
is
is-
existing.
There is
So,
a specific
one minute.
mention.
Road, we have understood the junior civil judge says that road is existing. Now, what have you done after 17 to 23? Why are you seeking vacation of this order? You want people to use this road?
Yes, my lords, there are about 25,000 inhabitants, my lords. There are colonies. This Nirmal area, my lords, was newly formed district, my lords.
Huh?
This area, the Nirmal
No,
town,
25,000 colonies,
inhabitants, my lords.
inhabitants.
And there are, my lords, houses,
25,000
including
no, no.
double bedroom houses, my lords.
Want 25,000 inhabitants?
Yes,
What? They use the road.
yes, my lords.
And you are not permitting them to use the road. No, what is the present situation? Because an interim order, you are not permitting them to use the road. Therefore, you want the stay should be vacated so that you can construct the road, repair the road and allow it for public use.
Yes,
Huh?
my lords. Page 80 in my counter, my lords.
No, we are asking, please tell, mister. We will go to 80, 180, everything. But please tell your submissions first. First is 60 years old. It's not that difficult, mister. Every case you seem like review of Keshwanand Bharti. So difficult.
And my lords, another
What
public
is submission number?
2 is, my lords, another public interest 179 was filed by the very same petitioner in respect of, my lords, all the tanks. In the
No, mister, you left the second submission midway. 25,000 inhabitants use the road.
Yes,
So, have they been deprived from using the road? This is not question answer session.
yes, my lords.
We will record everything. You have not said anything. You have said use the road.
There are
Therefore, you are guilty of violating the order because you are permitting 25,000 people to use the road.
Plus, there are about 5,000 houses, including 2 double bedroom houses, my lords, in the vicinity.
That we will not permit. No. So what happened? 25,000 inhabitants?
So as it is for their usage, my lords.
Usage. So you are not permitting the usage because of interim order. Huh?
We are not.
No. You will have to take a
We
stand.
are not able to complete that, my lords. They are using it, my lords. We are not able to complete the
25,000 people using the road. But who is not? We means respondents. All of them.
My lords.
We means who? Respondents.
Yes,
everyone. Respondents are unable to construct the road.
Complete the road. It's complete. Only the dispute is only with respect to a small chunk, my lords.
Complete the road. What else?
In the as regards fencing of the
now third submission.
As regards the fencing, my lords, of the lake is concerned, another public interest was filed 179 P.
Have you done fencing?
What we have done, my lords, we have filed a report in that, my lords. That is what my submission.
Done?
It is. If the fence, it is
Done or
incorrect.
not done?
Not done. 3 sides done, 1 side not done.
Huh?
3 sides done, 1 side not done.
Because the other side, the road exists, my lords. That is what, my lords. All 3 sides we have filed, my lords, fenced it. I have filed the photographs.
No. Fencing of full tank level is required to be done, not road.
No, the other 3 sides we have done, completed, my lords.
You have filed contempt for not fencing also, right?
Yes. I filed.
He is admitting, not done.
Yes.
That's what we had warned you, Mr. Counsel. By arguing this, you are getting the contempt petition decided like he will rely on this order to say that you should be punished. These are your submissions. In your anxiety to get the order of stay vacated, you are helping him in saying that please punish them for contempt. These are your submissions. That you are allowing 25,000 people to use the road. Then you have not told us what have you done now after this order dated 25 to 2017. Again, we are asking 17 to 2023. What have you done? No, you did nothing.
After receiving my instructions, after that they have not done anything after the orders. After they were communicated.
No steps taken to repair the road.
Afterwards.
Repair the road after 17 to 23, right? Yes, Mr. Go ahead. Everybody is waiting. This is not that Keshwanand Bharti we told, no? Only a matter whether stay should be vacated or not. Next.
In the public interest earlier, page 179, in bill 179, we have filed a report before this honorable court. With respect to all the tanks in Nirmal town, page 18 of my counter, with respect to Kottacheru also, we have categorically stated we have fenced it, except on the roadside. Then photographs are enclosed showing the old existence of the road at page 51 onwards. And the proceedings also enclose sanctioning of the budget for fencing of the FTL.
That's it. Anything else?
We have contemplated this action only for the public utility. And page 80, page 80 for a moment as the inhabitants and all the Google map which shows there are double bedroom houses and there is a temple Mahalakshmi Vada and double bedroom houses, everything.
Come to page 42, Mr. Brother is pointing out annexure P1. What meets the naked eye sitting here? What do you see? Second photograph at page 42.
Yes, ma'am.
What is being done? Tell me.
If it is your case that there existed a road and you are strengthening it, you mean to say there existed a road in the water?
No, in the public earlier writ page 51.
No, Mr. We are very really, we appreciate this chief engineer, revenue divisional officer, superintending engineer. They are risking their job for people. Very good. We're risking their job for the people. We have rarely come across, and we come across pollution control board who doesn't act, and see how these officers are risking their job for people. Because you are saying that chief engineer has no interest in the road and he is doing it for public, and by constructing a road, new road, by this thing filling up the water body, this he cannot do. Mantri tech zone, nobody can do. Even if we want to this thing build our house there, we can't do it.
That's correct.
Final word. Anything else? This falls in which district?
Nirmal district.
Nirmal. So We will direct PDJ to visit the spot and to submit a report in seal cover, which will help us in deciding contempt and deciding the question of quantum based on the finding of the district judge. Either way, it may be in your favor also.
Page 51.
But you are required to respect the order passed by this court on 17-2. You can't do anything. It's not a case for vacation of stay. Clear terms we are telling you.
As this is the road which was in existence prior to this. The
which page?
Page 51 in my counter.
Counter.
And fencing mailers also we have filed photographs.
Yes, ma'am. Right.
Page 51.
District judge, district Nirmal will district. Nirmal district PDJ will visit and submit the report in seal cover. These questions, your argument doesn't matter, nor Mr. Reddy's matters. Heard on the question of admission, petition is admitted for hearing. 1 minute.
One submission shall I make in the larger public interest, your lordship?
Not to admit the petition.
No, no, in respect of your lordship, to assist this court and to protect the, thanks your lordship. Earlier, I filed a public interest litigation. This honorable court has ordered for judicial inquiry. In the judicial inquiry, it was found that there is a small road. I agree. Subsequently, after noticing in that writ bill, your lordship, this honorable court has specifically directed them to fence it. They have violated that order. Then I gave a representation, don't give the notification in respect of that land because it's falling in the FTL. They did not agree for that. And subsequently, your lordship, they page number 68, your lordship, the order.
Again, you want to argue same
Don't
thing,
want
Mr. Over and over again. 9/8/2023, 1, 2, 3 submissions are 4 are recorded.
Plus, deeply.
Every time it is listed, you cannot argue and waste half an hour's court
I
time.
apologize for inconvenience of
This is all recorded.
Yes.
1, 2, 3, 4. For your satisfaction, please go through it and then
No,
submit.
I
Show
apologize.
it. No, you go through it. Why?
I'm leaving.
We have wasted so much of time. We do it again.
I apologize. Your
Please see. We will be satisfied. For our benefit, you go through it. The orders passed in your presence after hearing you are required to be told to you. And you also want to see any order parity article 14 we cannot violate. This file will come there. Please see any order. You see the interim order of which you are seeking vacation. Please see, give it to him. Vacation of 17/2/23 order. Read it. Correct, Mr. Reddy. Submissions recorded, heard. Third time it is coming.
I apologize for inconvenience to this honorable.
Not inconvenience. The future of students at stake.
Yes.
We are sitting here, Mr. We can conveniently hear this case till 4:30 and tell Mr. Rao that number is not reached and tell students who are waiting that number is not reached. What is big deal about it? Mantri Tech Zone doesn't permit all this activity, you know. You have not brought that decision.
I apologize.
It's all question. This thing, they will say certified copy today and they will board the flight and go to Supreme Court. You also want to go, please go. That we will sentence them. It depending upon this, all is needs to be. Please listen to the order.
Pleasure.
We don't want that our order should be. Supposing if we sitting here, we hold that they have committed contempt. The first ground of attack will be these questions could not have been adjudicated. There was no adjudication in the writ petition and High Court has allowed the petition. It will be stayed. Then you will say before public interest, it should not be admitted. We are directing the district judge to visit and give us an inquiry report in seal cover so that contempt and all these submissions can be. Whether road existed, we cannot decide in writ petition. And your admission will not, this thing that a narrow road existed. Nothing turns upon. This report submitted by
Junior civil.
PDJ will be binding on both of you or not?
Binding.
You will accept the report, sort inspection report which is submitted by PDJ?
Yes.
Yes. That is conclusive proof. That will determine whether they have audited, whether after interim order they have carried on construction, they have, whether they have not, whether or not they have constructed, fenced the area. Because the direction is to fence the area. If they were unable to fence the area, they should have filed an application for modification. They have not done it. You will have to face music, Mr. You yourself are saying direction is to fence area. If for some reason you are unable to do it, bona fide you should have approached the sport saying that, sir, only three sites we have fenced, another side we are unable to fence XYZ reason, please modify. No prayer for modification. So you have definitely violated the order. There is no doubt about it on your own submissions that you have said that it has been only fenced from 3 areas. Given a weapon to the petitioner to punish. That's why we told.
The other appeal is pending.
Fine.
179 is pending. 179 of.
There may be 100 pills pending, but the question is the order dated 17/2/2023 operates and binds you. Your officers cannot flout the order. We will not permit it to happen. And on your own submissions, you have flouted the order. Because you have not fenced the tank completely, on one side you have left. Admitted violation. Only we have to decide now on the report, we will decide what to do. Mr. Nobody can encroach this thing, buffer zone of a lake. This is a decision of Supreme Court. Minister, everybody. You, your minister, everybody, nobody can do it. Chief engineer, executive engineer, public 25,000 residents, nobody can do. If you are so concerned, make an alternative route for them. If you cannot make them, then provide a helipad and carry them. But this can't be permitted. Airport, construct a dedicated service, provide them free of cost to and fro wherever they want to go. If there is nothing. But we cannot, under Article 226, permit flouting of the directions issued by Supreme Court in monthly text zone. You read it first, judgment, and then they argue. Even if there was a road, it disappears. And advise your officers not to put at stake their job for 25,000 people, because are they contesting elections, chief engineer and this thing? They are putting the job at stake. That means they don't need salary. That's simple. They don't need salary from the government. They are so affluent. Advise them properly. Why this purpose is not to this thing, not to say anything bad to you. Purpose is so that you convey the seriousness. That's always the purpose. I don't even know your name. There's nothing against you. But you should convey this thing that they are playing with their jobs. If they are convicted, definitely we will direct the government to take disciplinary action against them. That's for sure. You go. This is being said to convey the seriousness of the issue which you are not realizing. You are saying that just by saying that 60 years road exists, I will get away. And on your own submissions, you have fortified his case for contempt. Heard on the question of admission, appeal is admitted, petition is admitted for hearing. Heard on IA number so and so, whatever, an application seeking vacation of the stay. Learned counsel for the learned additional government advocate or whosoever submits that the tank, that the road in question exists for 60 years on the tank. Road is situate on the tank which is exist
Not on the tank, but FTL limits, minutes on the
beyond. collector, chief engineer, district collector Nirmal, chief engineer and revenue divisional officer. A notice to these people also. The inspection shall be carried out in their presence. Right? Now this decides whatever. The report to this court shall be submitted in sealed cover. Anything else? Not covered. Whether the road is in existence, you have written, right? Existence, huh? Since when? What is the question? Existence. The width of the road shall also be indicated in the report. In addition, the report shall also state whether the respondents have taken any action either to widen the existing road or to construct a new road. Let the report in sealed cover be submitted before this court. Within Mr. Reddy, nearly an hour. Yes. What?
Please, your lordship.
Which case? Mr. Yes, Prabhakar.
I have submitted synopsis before your lordships in the last occasion.
What NCC? You are NCC, right?
This is teacher transfer service rules, my lord. By providing 10 points extra to spouse and teachers association.
We understand the concern that no transfers, they are unable to make any transfer.
We are restrained from.
And so they are unable to make transfer. So people are unable to go to, there is an administrative tribunal here.
No.
The High Court. So they are unable to come to the High Court challenging the transfer. He is worried that people should come to the High Court.
Actually,
and state as a model, this thing, state should contribute to litigation of this increase.
Yes, but the state doesn't have power to act on illegal, my lord.
Lighter when Mr. Come on, like now, yes, now what is the case?
Yes, actually, my lord, prior to formation of the state of Telangana, my lord, every.
We are hearing, Mr. 1 minute, we are not hearing it finally. It's on vacation, right? Vacate petition. So why are you arguing? You have not filed vacate petition. He is not arguing.
Yes.
I filed.
You will answer whatever he argues. Supposing if he doesn't argue, then you need not answer.
I am ready to argue. An order passed by this honorable court on 17/3/2023, your lordship will find it page number 14, counter, your lordship may kindly, page number 14. Just on the ground that rules have not been laid before the assembly. Now by the time this, your lordship may kindly see page number, order begins at page number 14, filed along with my counter. Well, at page number 15, the operative portion begins to run like this.
No, there is no order. This is an undertaking on behalf of the government. Please read. When this court indicated.
Yes, my lord, the court indicated. When this court indicated its inclination to restrain the respondents from taking further steps on the basis of the Telangana Teachers Regulations of Transfer Rule 2023, Mr. N. Ramlu, learned special government feeder, submits on instruction that state will not take any steps on the basis of the aforesaid rules till the next date. In the meanwhile, the respondents are restrained from taking further steps on the basis of the aforesaid rules. Well, the rules which are laid down under GOMS 5, dated 25/1/2023. Next page, your lordship may kindly see these rules at page number 18, my lord.
So what is your submission?
My submission is the rules were
laid down. We have to tell you, please tell submission, then elaborate.
Yes, my lord.
Every day I have to do that exercise. Please tell 1, 2, 3, then elaborate. Page 18, we will come all 2 pages,
yes,
all pages, but First tell what are your submission, 1, 2, 3, why do you want vacation of stay? Simple.
Yes, my lord. The government, my lord, after State Reorganization Act, my lord, there was a delay in bringing about into effect the presidential order. Pursuant to the
Maybe this thing. And here, mentioning of current program, you need to be documented. If you can place it. See, there is power 78 and 79. And that merely because it said that it. Then this is 19 Act. This is 78 to 19. Now this thing not laid before legislature. He says it has been laid. So, Mr.
Yes.
We will formulate the submissions for you. You are unable to do so. That the rules have been made in excess. Note down, Mr. Note down. You have to answer. Rules, he is unable to formulate. We are doing it. Rules have been made in exercise of powers under section 78 and 99 of the Act. Second is the finding that it has not been laid is incorrect, or subsequently it has been laid.
split. My lord.
When?
Well, in the month of August, when the assembly was commenced, last session commenced, well,
Late before Parliament.
2002,
Late before the assembly.
Yes.
Assembly. What else? Third submission.
Submission, my lord, in exercise the power conferred under section 70I, which
We
empowers,
said, we told no, that
Yes.
is the first submission.
Which-
Acts have been,
which empowers,
we are hearing.
I'm sorry,
This is open. I have not closed it like this. Go ahead.
which empowers the government to lay the rules in order to effect the transfers. While laying it down, my lord, it
Yes, yes. It's not so difficult. Not review of Keshwanand Bharti again, mister. You work so hard. I mean, like, what is, there's nothing not to understand. We have told you it is laid down under section 78 and it is framed under, again, we have to repeat for you.
yes, my lord,
Don't argue. Mister. Anything else?
nothing. These are rules were laid down. My lord, that is in compliance with the section 78 and 90. My lord, with immediate effect from 25/1/2023, rules have come into force. My lord, therefore,
August
my lord,
23, when, what date? There has to be a date.
2023.
Huh?
In assembly, it was led on 5/8/2023.
was explained on 25/1/2020.
No, but he said August 23 rules have been.
Rules were laid in the assembly.
Initially, they were, after the rage was done, they were laid before the assembly. They were issued on 25th January 2020.
The rules were placed before the assembly on when?
He is not.
On 5/8/2023.
5/8.
5/8/2023.
But that's what we are asking. You are not telling August 23, you said. So today's 30th August, so we were wondering when 29 days, when have you placed?
Yes, 5/8/2023 rules were laid down.
Okay.
My lord, even rules have deemed to have come into effect from the, when the rules were framed. But however, by the stay granted by this honorable court, we could not proceed with the transfers. Therefore, my lord, rules were laid and which have to be given effect.
These rules pertain to transfer of persons, teachers.
Transfers.
Transfer of teachers.
Regulations of transfer rules 2023. That, my lord, which clarifies section rules 6.
So therefore, what is, therefore what? So therefore stay should be vacated.
They should be vacated.
Mr. Prabhat. So Mr. One thing,
Yes, Miller.
we can give you tens of, like several judgments of Supreme Court.
Yes.
Mere quoting a wrong provision.
Yes.
When the source of power is available.
Yes.
Why have you stood up? You are sitting down, right? So, mere quoting of a wrong provision in the rules will not invalidate if the power can be traced. So power, legislative power can be traced to section 78 and 99 of the Act. In exercise of that power, the rules have been framed. Merely because it refers to 309, Article 309, that will not invalidate the rules, number one. Secondly, they have said it has been laid in the assembly on 5th of August 23. The whole transfers in the state have come to a standstill. This sort of a situation, it can't be countenanced. The government cannot be deprived, denuded of its administrative power. There may be people who are wanting transfer on mutual basis, medical emergency, somebody's wife must be suffering from cancer or a terminal disease. You cannot get a blanket sort of an order, no transfer in the state of Telangana can be made.
So now my first submission before your lordships.
Yes, Mr. That's
First
like
submission is
Mr.
Milad.
Prabhakar.
Yes. My first submission is,
He has only argued 2 points.
yes, only he has argued 2 points, Milad, but where I need to establish my case, only 5 points. Your lordship.
Number one.
One, Milad, the government is having power under Article 309, under Section 78, 79, but doesn't have power to provide the 10 points extra to the teachers association leaders and spouses. It's a violation of Article 14, 16, 21 of the Constitution.
But that is not the ground on which stay has been granted to you.
Your lordship,
Because, no, why he has read
yes,
it?
yes.
Because-
They also granted Milad.
1 minute. We are into a debate, right? Not and your enemy, Mr. Prabhakar, you know.
Yes.
We are not your enemy, you know. You appear for flood victims. How can we be your enemy?
Yeah.
So, 17/3/2023, I was not here, nor my brother was here.
Yes.
The bench which had passed the order has taken into account 2 points in granting you stay. What is the first point? That even though the power to frame the rules under the statute is with the government under section 78 and 99 of the act, yet the rules make a reference to 309. So your contention was that when a specific statutory provision is there which enables the government to make rules, reference cannot be made to 309. This is one. Second submission, you as recorded in the order 73/23 is that the rules have not been laid before the assembly.
Yes.
So those rules, now he has told that it has been laid before the assembly on 5th of August 23. These are the two submissions.
Yes.
Now you want to argue something new.
Yes. Now, Milad,
So these two answer.
earlier division bench.
So 5th of August 23
Yes.
rules have been laid before the assembly. You don't dispute it.
Yeah.
Do you dispute?
I can't dispute it.
You are disputing.
Yes.
Not laid.
Yes. And those were laid down. They were provided. They were provided. But no discussion took place in the assembly, and no modified has taken place in the assembly. Just provided and come back and submitted before your lordships, where of earlier division bench of this honorable court has passed the order after they have been provided. Procedural impropriety, your lordship well aware, procedural impropriety and irrationality can be straightly struck down by this honorable.
No, but you are there on 5 submissions. So what is first? That's a better way of arguing.
I am deep.
Yes. First submission
The
is
first
what?
submission, Milad, the 10 points for teachers.
Which provision 10 points?
Yes.
Let us understand.
Yes.
Which rule provide 10
At
points?
page 9, Milad. At
Page-
page 19, Milad.
90.
9. Common point starts from 19, Milad.
Yes. These are the rules.
Yes, Milad. These are the rules, Milad. First, in 5 sub rule 3, I may be permitted to read it. At page 19, 5 sub rule 3. May I, Milad?
See, yes, again, don't challenge the rule. How road geo can be They were wondering, Mr. Like same thing. It appears to be practice here that challenge the whole rules. Then in medical batch also we were hearing admission. We had to ask senior counsel. Then they said only rule 33B we are challenging. Same thing, this thing we were seeing your prayer clause, whole rules are challenged.
Policy decision itself is an.
The whole rules are challenged.
Yes, Millard. Yeah, policy decision is.
No, so therefore your.
That I have
1 minute, Mr. Prabhakar, let us try to understand. You want to say that this notification under section 78 and 79 and under article 309 cannot be issued. So therefore it has to go as a whole.
Yes.
Not a particular rule.
Yes. And in violation
So
of.
then you are arguing about rule 5. Then argue that these rules, this whole notification has to go because government has no power to issue notification.
No, Millard. Finally, I will come to that, Millard. Fact of the
So
case-
first point,
Yes.
that why government has no power under 78 and 79. Can this be?
78 and 79 government is a.
Seventy-eight and 90. He is not taken, must not have taken this ground.
What's that? Education.
This act is constituted for what? Not to provide for service condition. Service conditions are a different part of it. Then apart from this, 99 is 78.
78 is page 65.
Constitution. This 72 will come. Conditions of service. Transfer the condition of service. 78 is. Same condition of service. So, Mr. Prabhakar, you must have seen, you as an advocate, you know, and that's why we are able to tell you you are a fair counsel. That's why the upshot of discussion is what we had is that under section 78(2) of the Act, the government has power to frame rules.
Yes.
In respect of condition of service, right? That is the first point. So they have power under 78(2). Now you are challenging rule 5 on the ground that it is arbitrary.
Yes.
Correct?
Five.
Now let us, so you will have to make a statement that you are not challenging notification as a whole, but some rule, whatever you want to challenge.
I have challenged the whole notification because it is procedurally impropriety and why it
No.
first arbitrary.
So 1 minute. So whole notification, what can it be challenged? Whole notification can be challenged on the ground that government has no power to frame rules. Why do you say so? No power.
If though government is having power,
Happens to.
is
That's why we are asking you
Yes.
relevant. 1 minute. Listen to question, Mr. what we decide matters, no? Therefore, you must listen to us.
Yeah, okay.
So 78(2), conditions of service, transfer is a condition of service. They can frame rules with regard to transfer.
But
Correct.
Lordships, after
So
completion of Lordships, I will.
Therefore, we can understand that if you're challenging particular provisions, saying Rule 5 is arbitrary, violative of Article 14, understandable. But you are saying the whole notification is void or illegal. How? What ground?
That's section 19 state that Millard, they have to provide the rules before the assembly.
Then Mr. Prabhakar, you started on a very good note, telling us submissions first, 5 submissions, right?
Yes.
So first tell us 5 submissions, then we go to whatever, 99, 78,
Yes.
whatever. What is first submission?
The first submission is Millard,
Hmm.
where the already they were transferred the teachers under GOMS number 317 in the year 2021, and schools are running at present and issued these rules in the month of 25/1/2023 without following the due process of law.
What? Acha, rules enacted
is
1 minute. Rules enacted without following
due process of law. Due process of law. That is my main ground.
What is second submission?
The second submission, Millard, Rule 6A and C of the Rule, Millard, 6A and C, page 20, Millard, by providing the.
No, there is no A.
Yes, Millard.
A.
Page 20, Millard.
Ah, yes.
Page 20, Millard.
No.
A and C.
So Roman 1 or 2? What is Roman 2? 1. Because
Roman 2,
both the clauses have A.
Roman
Common points 6A.
Lordships, Roman 2, Millard.
6.
Roman
Rule 6, Roman 2, then A.
And C, Millard, these are all providing the extra points to the Teachers Association presidents and
1 minute. Extra points to the president of Teacher Association.
Yes.
Extra point for what?
Every year completed service, Millard, in participating the transfer, they will be promoted by providing these points to select their option, Millard.
For each completed year of service.
Yes, ma'am. Each
so how if he has completed 20 years, so he will be granted extra. How many extra point for 1 year, supposing? And
Max points only 10.
Huh?
Maximum points only 10.
Ceiling is 10. Okay. Doesn't make any difference.
No, Millard. That makes much difference, Millard. That's only our main ground, that is an arbitrary and discriminatory, Millard. Lordships, in my synopsis.
So read where is that?
Yes.
Extra point for every year up to how many 100 points or 200 points?
Yes.
Where is that?
Yep. In my synopsis, at para 6.
So how much point?
In my synopsis, at para 6.
6 to A, read, Mr. Jiva. Acha, we will read it like so.
No, I am
1 minute. We will read.
I will read.
So Rule 6A and C, extra point to President of Teacher Association in respect of each completed year of service. Correct, Mr.
Yes.
Prabhakar?
Yes.
Third is what? No, this is what. So therefore it is arbitrary.
Yes, but it is arbitrary and discriminatory also, Millard, among the teachers, those who are working as.
Fine, next.
Next, Millard, C, 10 points per spouse, Millard.
Huh?
Spouse.
Which clause
C.
B?
C.
Rule 6.
C, Millard.
2B. C.
C, Millard.
10 points for
spouse whose spouse is working in the same district. Same district.
So 10 points only.
10 points.
Not any unlimited point, 10
Yes,
points.
10 points. So these
This is also arbitrary,
Arbitrary and
discriminatory.
discriminatory.
No, probably, I don't know whether you should urge the sleeve of discrimination, because discrimination is similarly situate persons treated differently. So here it is carving out a class of employees whose spouse is employed in state government and central government. That's a class by itself. You can say classification is arbitrary, not discriminatory, because you are not the one whose wife is employed in either central government or state government or public sector undertaking, local body aided institution.
So,
right. Number four submission.
Now, fourth submission, my lord, the whole process is, my lord, illegal, my lord, and impropriety.
What process?
The rules have been made by the
That
state.
you said not following due procedure of law.
That's already covered.
Covered. So 1, 2, 3. What
Yes.
is the fourth submission?
Fourth submission, my lord, already the rules were there, my lord. And overriding those rules, again they have been
They can make new rules.
and that is in force, my lord. Your lordship may kind see.
Which rule?
Your lordship.
Which rule?
QMS number 182 dated 21/5/2016. Lordship.
120? No, not don't want the
182.
number is doesn't matter.
Yes,
Right,
21/5/2016.
What is it? 21/5/16?
Your lordship, state government has been issued this rules.
Transfer rules. Same
Transfer
rules.
rules, my lord. There are two, my lord.
Not repealed.
Yes, not repealed. Not repealed. It is in force.
Oh.
That's their bad faith, my lord, so that already they were having.
This
they
is
have been issued.
this an order, right?
Yes, my lord. Gee.
One page.
Yes, my lord. There are two, my lord. May I read, my lord? Government, after careful examination of the entire issue in detail and as matter of policy, hereby decide and accord permission to the secretary to government administrative department to transfer the employees working in the state government whose spouses are working in central government, state government, local bodies, state level public sector undertakings from one local cadre to another within the same local cadre as the case may be on spouse grounds, provided there shall be clear vacancy in the respective post and they shall be assigned last rank in seniority in respective post in the latter local cadre, treating it as a record.
We have read it.
Yes.
So this is what issued under which provision of law? You are describing it as a rule. This is a matter of policy by which the powers have been delegated.
Yes, my lord. These rules are applicable to teachers also, my
No
lord.
rules. These are not rules, Mr.
Yes, sir.
If you are understanding it rules, we are trying to tell you it is not a rule. It's only an policy decision taken in exercise of powers under Article 162.
So, this is this one.
All right.
The last one is, my lord.
Hmm.
If the 10 points are being provided to the teachers and the spouses, remaining teachers are losing their service, my lord.
Why losing? They will not be out of job. They will not be transferred. Oh, today is like a, what's the temperature, Mr. Prabhakar? First time, twice we have.
So, kind concern for 1 minute, my lord.
No,
My synopsis said para 6 years.
No, but we are trying to understand. Just now you said that they will lose job. So how they will lose job?
Lordship, so service I'm submitting with
And they will lose service, you said.
service.
How?
How? Because seniority is going, my lord. They are losing their seniority by implementing the same. I have already stated in my synopsis.
Hey, one minute. Don't get agitated. We are trying to understand step by step. Supposing you are a teacher.
Yes.
Your wife is this thing. You are a president of teacher association,
Yes.
correct?
Yes.
So they will give you, say, supposing some preference marks, right? So you are in some district away from Hyderabad. You want obviously to come to Hyderabad, right? You make an application for transfer. The government prescribes applies the criteria. and gives you additional point and you are transferred to Hyderabad. So how a person who is posted in the remaining district will be affected? I mean, his seniority he will go down. How the rule operates? You are saying that that he will lose his service.
So
That you want to understand.
losing their service in future, they won't transfer Mila because
Mr. Prabhakar,
per minute.
no, 1 second. They will not lose seniority. This 10 marks or 10 points will be utilized only for affecting the transfers. When considering yearly transfers or whatever it is, only during that period, one seniority based on your year of service you have put in, you will get marks. In addition to that, this maximum of 10 marks is added so that for you to be eligible for being considered for a particular place, if you are president or secretary, that is one. Based on spouse ground also, the other 10% marks will be considered so that both spouses can live together. That's all. But in terms of seniority, nothing will be affected because seniority will be determined for the purpose of your promotion and other things. That will not get altered.
But at present, I won't transfer to other district. That is also my grievance, Miller.
I mean, you will not be transferred. That's
Yes,
a different thing.
yes,
But
if-
saying that I will lose service is different.
Lordship super, Miller, my
No, no,
synopsis at page
no, no.
6, Miller, final submission, Miller.
Mr. Prabhakar, we understand that you are losing your right of consideration for a transfer
Yes,
to Hyderabad.
yes, yes, Miller.
That is correct.
Yes, yes, yes.
By this
Yes.
arbitrary exercise of power.
Yes.
That is understandable.
Yes.
But you will not lose your service. We will say so that you will not lose service.
At
Ah.
para 6,
Next.
at para 6, Millard, I may be permitted to read my synopsis, Millard.
Which
My-
will not-
my-
when have you given, Mr.?
Already I have given Millard.
Hey, when did you give? So nice.
Yes.
Memo.
No, this is.
Array, Mr. Additional Advocate General, you are ready for this, whatever he is arguing? Because you have only argued with regard to the points mentioned in interim order. Interim order is not everything. We have to, the court indicates some reason prima facie to grant an interim order. He is arguing on altogether 1 minute different grounds than the one argued by you.
Yes, I'm ready.
You are ready.
I'm ready to
That's only hope that you are ready.
I'm ready.
We will find out whether you are ready or not in a short while from now. Okay. Yes, Mr. Prabhakar.
Sir, para 6, Millard. It is
Synopsis.
submitted that the points to teacher whose spouse are not working in the government or public sector undertakings. Heading. A teacher had.
That is correct. That is arbitrary. We have understood.
Yes.
They will have to prima facie disclose what is the basis for granting a preference.
So by this, Millard, spouse and teachers associations are having only limited, Millard, and the remaining all are discriminating, Millard. This is my final submission.
Final, yes. So the in substance, Mr. Your submission is Rule 6, 2 clauses A and C are hit by Article 14.
Yes.
Arbitrary
I'm deeply
and classification is not based on any rational, any reasonable criteria.
Yes, I'm deeply.
That's it.
That's
long and short of it.
Yes,
But
deeply.
the whole rule is not, therefore you should amend the prayer clause.
Pursuant of that, I have submitted judgments, Millard.
Of course, this you are only arguing on vacating stay. We are not deciding.
Yes. Deeply. That's it.
Yes, my lord. This rule, my letter.
Mr. One thing, Mr. Prabhakar, one thing we have to, you said that rule has been enacted without following due procedure of law.
Yes.
What is due procedure?
The due procedure, Millard, categorically stated that, Millard, prior to implementations of the rule, Section 99 categorically states that, Millard, to provide before assembly. And the assembly has to be debated and to take decision. But nothing was taken place. Just they were provided in assembly and brought before your lordships. Already we have been provided. It is also an
after you filed the writ petition.
After that, it is not valid in the
Correct. Understood. Yes.
Great.
Now we have understood all your points. Yes.
That
There are some other mountains appearing for petition.
Yeah, please.
My case,
We are only hearing on vacation of stay, right?
I am also one of the petitioners.
Huh?
I am also petitioner.
Yes, anything else?
My case,
Which WP?
WP 3962.
3962. Yes.
I filed this repetition.
You have challenged the virus.
Entire rules. If Rashu so pleases, kindly see the relief sought. The relief sought in the repetition, Your Lordship may.
What is the, you tell us, we are here to assist us.
The entire rules issued by the Milord State Board.
They are void ab initio.
Where they put in authority and power. And alternatively, I sought Milord the rule 6(2)(a) and C as unconstitutional.
That's what we told Mr. Prabhakar.
Yes, that is right. Here, I challenged the rules on the ground that they issued rules invoking power under Article 309 of the Constitution of India as well as Section 7899 of Education Act 1982. I made a submission in my affidavit. If they wanted to invoke 309, 309 is only legislator got power to frame the rules. And even proviso to Article 309, that is power vested with the governor. That not general power under Article 160.
Power under 309.
309, legislator got power.
They have no power to frame under 309.
309, the state government.
They don't have power.
No power, only legislator. Enactment, by way of enactment, they can make, but not by way of rules. And even assuming that proviso under Article 309 of the Constitution of India, the governor of the state got power to frame the rules. Governor or authorized person under provision to Article 309, governor or his authorized person got power to frame the rules. In the present case, the exercise of power under Article 162 of the Constitution of India without any resolution passed by the cabinet.
The rules have been framed to 78, maintaining approval and the army
Yes.
Without even circulating the file to governor, as if it is a executive power, as available under Article 163.
You are saying that it is rules have been framed under Article 162.
Yes, like that. They are not exercised.
Article 162.
162 of the Constitution, like executive instruction.
Next.
Then, even as per 78 and 79 also, the Act not provided to frame the service conditions of the government employees. The very objective of the Act is only regarding private and other institutions, and Act not legislated, enacted under provision under Article 309 of the Constitution of India. If they wanted to enact legislator under Article 309, even provision to Article 309, they should consult Public Service Commission. All these things not there. Your Lordship kindly take the Act itself, Education Act.
We only tell you, remind you that you are arguing vacating stay, right?
Initially,
what argue on merits?
Initially,
briefly you can tell us.
Yes. Initially, when we made all submissions,
all submissions are there in the order. Only two submissions. Please read the order.
One point. Order. Your Lordship kindly take.
Please read the order.
Yes.
You read. We have read it.
My order. Challenge made in this petition. This is the order dated 14th February.
Don't read, Mr. We have read it. We have read.
That is Prabhakar case of Verma.
And your case is different.
Different. My case is
Other-
February,
One
case
minute.
is March.
Madam, what is this case order? That's what we will read faster than you. That's why saving time, nothing else. Saving time. Same order. Same order. It's
Yes,
not
madam.
different.
First February,
What we are trying to tell you is, Mr.
My
that
case,
you
no.
people now at the stage of vacation are arguing different case, this thing, submissions.
Correct.
Then they have been noticed in the order.
Yes.
That order only noticed that rules we need not repeat, you must have read at home.
Yes.
Next. Yes.
But my plea,
So 1, 2, 3, 4. Next submission.
but I made a submission that even but as per the Act, Education Act 82, the government is not having any power under section 78 or 99 to frame the rules pertaining to government employees.
That we have noted down. Last submission.
As the rules already existing for government employees issued under
Where is-
provision to Article 309.
Where is that?
That is Education Subordinate Service Rules, Volume 3.
What are the rules name?
There is one is on this Telangana School Education Subordinate Service Rules. And originally AP School
No, what is Telangana School Education Subordinate? What
rules pertaining to service.
name of the rules we want to?
Here, the Andhra Pradesh School Education Subordinate.
You said Telangana. Now you are saying.
The adapted after bifurcation.
So
Adapted all.
Telangana. Please tell the name of the rule, Mr.
As of now, is Andhra Pradesh only. They will adapt Telangana School Education Subordinate Rules.
Subordinate school.
Subordinate Service Rules.
Subordinate.
Service Rules.
Which year?
This is Virat. This is Virat 2005.
So which provision provides for transfer of government teachers? In
These
this
all
rule.
pertaining. Yes, yes.
No, which is the,
Virat. Yes.
please understand the question, right?
Yes.
What we write matters,
Yes.
right? So please understand the query, which rule provides for transfer of government teacher?
Yes.
Criteria it lays down, or is there is no rule?
Yes, yes.
Or if it is there, please tell the rule. Answer can be yes or no.
But in these rules,
And there can be third also, I don't know.
there is no provision for transfers.
No provision. Correct.
But status of the status about rules that govern all the employees.
Yes. So no. So there.
38, Rule 38. Rule 38.
Rule 30. You said no provision for transfer. There is a provision.
Provision. But
So
not-
that earlier statement you are withdrawing that there is no provision.
There are two kinds of rules. AP Education, Telangana Education Subordinate Rules is a special rule.
2005. Government teachers.
Teachers
Ah.
and Panchayat Raj.
And you told that there is no provision in those rules for transfer.
There is no provision.
Which other rule?
General rules.
Which general rule?
38. The Telangana State and Subordinate Rules.
Telangana?
State and Subordinate Service Rules.
State?
State and Subordinate Rules. Service Rules.
State and subordinate.
Subordinate Service.
State and subordinate service rules. Which year?
That is not 90. 92.
92.
Yes, 96.
96. Which rule?
38. Rule 38.
What?
92.
92.
Yes, 96.
96. Which rule?
38. Rule 38.
What does it say?
I will read. Posting and transfers. A member of state service or class of state service may be posted to any post foreign on the cadre, such service or class of service anywhere in the state, provided that such postings and transfers shall be limited.
No, that it doesn't provide criteria like the one in the rules. It only says that he can be posted anywhere in the state.
That is the state officers. The rules govern the state and subordinates. Next minute,
So you are saying that teacher can be transferred under these general rules.
that is, yes, madam. That is state officers. That is, madam, they can be posted anywhere. The subordinate officers can be posted within the district.
Subordinate officer, that is subordinate officer is teacher.
Teachers like that, not district cadre. Under president order, it's not very new.
No, Mr. What you must have read the principles of statutory interpretation saying that when there are special rules, then they will apply. General rules will have no application. You have just now given us special rules of teachers, government teachers. So these general rules will not apply to government teachers.
Regarding transfer is not available.
So therefore this general rule will. So therefore you say that in view of rule 38, government cannot enact this.
Already rules are there.
So government cannot enact another rule, another set of rules. Correct.
Now after filing,
what else?
Then
Sixth point is we have noted down. What is seventh point?
Alternative. Not I challenge as I said, not submitted. Rule 6A and C.
Yes.
First part is entire competence of the government to frame the rule.
Yes.
That is first part. Entire rules challenge. Second alternative challenge is rule 6A and C, which provides 10 points to association.
Same thing.
Yeah,
Article 40.
Yes. And second, C is giving 10 points to spouses who are government employees. That is the difference. They are discriminating.
So it is arbitrary, right? No classification, no reasonable basis for classification.
Nexus
sought to be achieved. An object.
All are teachers, one class, one category under Article 40. You can't discriminate with regard to transfers. For allotment, your lordship, allotment, when the government given preference to only government, state government employees, this honorable court as interim measure held that there can't be discrimination between state government employees and central government employees for allocation. Here, the transfer within the district, but that they are giving so much preference to spouses who are government employees and spouses who are not government employees, who are discriminating. They are getting their choice wherever they wanted to go. Yes,
We can hear.
I'm sorry.
We are both of us are confirmed judges. That's why switch off then mic if you are accustomed to shouting. It creates a very distinct. Yes. No, it's all. Please. Yes, go ahead.
These not that they should do some preference. Spouses who are not government employees because they won't get income.
So you are arguing finally, right? We are tempted to decide it finally. The way you are arguing, despite being told that it's only on vacation of stay. You are such a elaborate thing. Seventh submission. What is eighth? That's all. Fine. That we understand, right? Mr. Prabhakar has argued, no? I mean, don't you have given additional points? We have noted it down. Anything else?
There are 3 elements state of Telangana.
MLC? What is MLC?
It says only in the director.
No, which petition have you implemented MLC? Then
I'm saying
How is it MLC relevant for validity of rule?
that grievances of the teachers. MLC is not
You are seeking a direction to MLC to consider your grievance. Alternatively, that
once MLCs are there, government are not competent to give preference with regard to transfer.
so once MLC is there, government cannot make rules.
No, not it is preference that are clarified. Authority is authority.
Arey, Mister, that's why you have challenged the validity of the rule, right? Not give means don't ask in about this thing. So they cannot give. That's why you have challenged the validity of the rules, irrespective of the fact whether or not MLC exists or not. It's a constitutional right to challenge the validity of the rules. You have challenged it. Fine.
Then after filing stage, they will have placed before we will have state person.
That he has told. 5th of August, and Mr. Prabhakar has argued that no consultation has taken place, just late, no discussion has taken place on the bill.
That
Mr. Understand, requirement of laying down before the assembly is a directory or mandatory requirement. First, before arguing, answer this query. If you are requiring on this issue, you are arguing finally, right? That's why. So tell us whether the requirement of laying down the rules before the assemblies are a mandatory requirement or a directory requirement. If it's a mandatory requirement not followed, what is the consequence? Answer two questions. Mandatory requirement, directory requirement. Where is, which case? But we are hearing vacating stay, right? You are arguing. No, we see, Mr. He has not argued anything. He has only argued 2 points. You have set up a new case. Now I will have to ask him to argue. Prima facie satisfaction why stay should be vacated. You have a favor, in your favor. You are arguing everything. This is not final hearing. Then if you then why invite the attention of this thing court and entail rejection of your submissions which can be raised appropriately after thorough research at the time of hearing. Please understand. You have argued enough for vacating stay. It's not then don't go into question of mandatory directory requirement. Then I will ask you, then which paragraph have you pleaded? You cannot argue anything like without.
But the husband that February, I think not 7 months back, I think 6 months back, not 20 months.
6 months back.
15 months back.
Whatever, whenever it was granted, it's there.
Therefore, the last 4 minutes, they finally, or how they want to but so reference to that sector, 268 not supposed to involve.
That's the solution. That's a solution on your behalf. That we accept. We will put them this question. That's it. No, sorry. You have argued. No, sir. No.
Unable to understand
That's what you should. That's why so many people keep on sitting here to watch us to understand the mind of the court. Because first important, one thing, lighter when, one we are telling you, most important thing is to understand the judge before arguing him. Before arguing before him, that is a tip which we are giving. All right. Mr. So, is it possible for you to effect transfers, deal with the legitimate transfers without giving effect to provisions of 6(2)(a) and C? Possible? Not possible.
Not possible. We have issued the GOMS.
So then we decide the issue, whether it should be vacation of stay or not.
Yes, balance.
6 to 7 but they can because they have their own field.
Actual person to level then you would be said, yes, with it, with the see if you suggest focus yes.
Let. Lordship, my hand is rule 6 millet of GOMS 5. The certain point.
No, first is no power to frame rules under Article 309.
Yes, in the writ petition filed by Mr. Krishna in item number 43, wherein I filed a counter, I stated the government while issuing GOMS 5, Article 309 is inadvertently cited in GO. And counter I stated, my lord. Lordship, may kindly see.
All right. No, so then inadvertently stated means this is a power under 78 and 99.
Yes, power under sense.
1 minute. Then his another submission was rule exists for government teachers, teacher, Telangana school education subordinate service rules 2005.
These rules, my lord, is no longer in force, my lord.
When have been repealed?
Not repealed, my lord, in view of the GOMS 5. In GOMS 5, it is sought to be effective for all transfers working under government.
No.
The transfer.
What is GOM? Arguing that says government order, they cannot say that not being they are not statutory rules. They are the rules framed under Act. When they are stated, that's why government order comes
This-
separate law. Again, other government. No, but it is an exercise of powers under the Act, not under the offense, which he is referring to as GOMS. What?
These are specifically, these are guidelines for.
No, 2005 rules have been repealed, you are saying.
Not repealed, these are not applicable in the present, these are applicable subordinate service rules other than the transfers. These are the specific rules were issued for the purpose of laying the guidelines for the purpose of.
No, 1 minute. We understand. Why this 2005 rules do not apply?
But the other than subordinate service rules, other than transfers. Other than transfer.
No. You said that 2005 rules do not apply. Why they are not teachers?
These are for subordinate services, the rules were issued not relating to the guidelines specifically affecting the transfers.
School education subordinate service rules. See, Mr. 1 minute.
Yes.
Mr. Additional Advocate General saying that the rules do not apply is different than saying that it does not have a provision for transfer. So you did first ascertain what you want to say, then tell us. These are two different things. Saying that rules do not apply to government teachers is one thing, and saying that those rules may apply but no provision for transfer is different. What do you want to say?
2005 rules have no provisions for transfer. These
that is 2005 rules. He admitted no provision for transfer.
Yes, these rules are under present.
Whatever.
Yes.
So it does not deal. Then Telangana State and Subordinate Service Rules 96, he said Rule 38 power. Rule 38. He referred no, Rule 38.
For transfers and subordinate conditions for verification required.
It only provides for transfer. 1 minute. So Telangana State and Subordinate Service Rules 96 only deal with transfer.
But it's not general for subordinate service. These present rules, guidelines for.
Oh, just a minute. So these subordinate rules 96 do not apply to government teachers, correct? Do not apply to government teacher.
There are no guidelines for
Specific guidelines are
General.
general rules.
subordinate service. I will to make myself. Subordinate service that take general service transfer for all categories.
Including government teachers.
But it's for the guidelines.
They provide for criteria. Right. One minute, one. Yes.
Guidelines. Not a transport. See guidelines for printing governments file which the papers are those. Rule 6.
1 minute, 1 minute.
6. That this point must not have.
What?
But it's for the presidents of the association.
And spouse serving in a government, state government SEBI. Why? What is the basis?
That not that this classification had been made, not that to achieve some, and there is a good difference. The employees without spice being spouse being worker, and the employees it's their spouse being employed, I will government services are public secretary are whenever this spouse works.
No. One first is A, which office bearer of association. Why?
Because they are where the officers are speaking, they have to look after the service conditions of all 80,000 employees. They are because they are the president.
No. So every president will, supposing conceive a situation that all presidents will seek transfer to Hyderabad. What happens?
That is not.
What is the object? And we are illustration trying to test the application of rule. Mr. Again, we are asking one more thing, Mr. Then we proceed. Is it possible for you to effect transfers have been state, right? You have undertaking. Is it possible for you to effect transfers for the time being without giving effect to clause 6 to A and C?
Yes, we can go ahead and transfer without communicating.
So we will deal with the challenge. Deal with the challenge. You go ahead. This thing, your concern is that the state government altogether has been stopped. Altogether has been stopped from. 1 minute. Listen, please try to understand. You are saying that your grievance is justified, that it can't be everything cannot be put to a standstill. And the government must have power to effect transfers for efficient administration. Nobody can take it away. So, but this rule 6A and C is under challenge. So, because of interim order, everything is standstill. So, we will, Mr. Additional Advocate General, you say that you are saying that we be permitted to effect transfers in respect of all other sons except C, 6 to A and C. Correct? Correct. So then everything that's the under challenge. Then what remains? No. You want to deal with spouse and president only and don't want to transfer any other employee. Correct? That's so.
Spouses, headmasters and education spouses declare their birthday. Spouses class to be considered. But in respect of the birthday, that not be not required. In respect of the house spouse, and we have to
It's to see also they can wait and the.
Ask him.
RHC large
One, just listen to. Without giving effect to 6 to A and C. 6 to A and C.
Yes.
A deals with president, secretary, C deals with spouse. Without a reference to this 2 A and C, can you not affect transfers? Consider, 1 second, listen. Considering the cases of spouses also in terms of GOMS number 182.
There. Right? All.
There is no idea.
Ah.
Not force.
Withdrawn?
Withdrawn wrong that. Withdrawn to service conditions like.
All right, it has been withdrawn. Then, Mr. Advocate General, Additional Advocate General, 6 to A and C for this thing, for the present. You effect all transfers.
Yes.
I applied for the union.
Ah.
This time, let the 6A be kept in abeyance.
6A and B, not C.
Ah.
6A be kept in abeyance.
And what about this thing? C.
6C, my lord, I am appearing.
Please.
6C.
Earlier rules which were superseded by this DO 5 are at page.
No, what do you say with regard to interim arrangement for 6 to 6?
Concession is being extended, not the first time they have introduced.
Which earlier?
That is in DOMS number 16.
Page what?
A similar provision in what rule?
Page 40. Page 52 minutes of the paper.
Which rule?
GOMS number 16.
Huh?
16 dated 6/6/2018.
16/6.
2018.
6th June.
6th June 2018.
At page 52. It starts at page 50.
Which petition? This is, we believe, 3962, right?
3962.
Page 52. All. Yes. So,
Even earlier to that, my lord. Even earlier to GO 16. GO 12. Your lordship may kindly have look at plot page 40. 40, my lord. 40, GO 12. GO 12. My lord, in all the earlier GOs.
GO 12 dated?
12 is dated 16/6/2015. In all the earlier GOs, the entitlement points, which we called as similar to
Like same type of preference to government teachers whose spouses in government, central government, state government, public service. Object is to bring them together so that couple can live together.
Yes, that is the, and in fact, your lordships are aware. Can I just?
All right. We have heard, yes.
My lord,
All right. That's why. Now you are this thing for the first time you want. 1 minute. So,
10 points are unreasonable, my lord, for some results.
yes, it's an interim order, Mr. Prabhakar. Please appreciate. Yes.
If you are
No, that is your submission. Now we decide what to do. Correct? You have also said, but that's the difficult job of judges. Every moment they have to keep on, 1 minute. Every moment you have to keep deciding what in ordinary life we keep on postponing to keep decision. We have to take decision every moment. You have said that A and C, everything should be permitted. They are saying except 6 to A, 6 to A, and they should be permitted in case of 6 to C. This is their submission. Now our order.
Can I just make one? Because your lordships are maybe dictating the judgment, my lord.
No, not judgment. In
Not today.
vacating.
Any day.
No, just now vacating.
No, what I am trying to say is just guiding your lordships, helping, assisting your lordships, my lord. 2005 rules were, my lord, superseded or they were set aside by its honorable court.
When?
My lord, this was in 2007. 28 to 2007, in a judgment, my lord, titled as Vema Reddy versus State of AB, my lord, these 2005 rules have been quashed.
Which is that judgment, if you can give us?
I'll give the citation, my lord.
Please, I mean,
Vema Reddy versus.
find out.
That rules are right.
No, that set aside.
Judgment రాసుకోండి.
One second. Anyhow, my lord, those rules are kindly just.
For purposes of interim order may not be, we will record your submission.
I was only trying to, my lord, assist your lordship saying
No,
that
we are not dictating the
your
judgment
lordships are-
finally.
if your lordships are referring to those rules,
No, we will have to record your submission, their submission, we will record your submission also that it
I'm
is
only trying to say those rules are not there in full.
not there. We will record your submission. Yes. Also, Mr. Prabhakar, now you will clarify that in your petition 6 to A and C, right?
Yes.
First submission is that they don't have power to issue rules, and alternatively you submit 6A, 2A and C, correct? Same case. Mark the presence of everyone. Heard on IA number. Which IA? IA 2 of 23. In WP 2856/2023 and IA number 8 of 23. 8 of IA number 6 of 23 and 8 of 23 in WP number
Local body.
Acha, delete the local bodies
means posted. And our case became infectious.
No infectious. Needless to state that where they are affected to transfer except in so and so, needless to state that the transfer so made shall be subject to outcome of this petition.
Transfers are affected.
So that's reasonable points may be provided, Milan. 5 points may be provided.
The objects of this thing, this order, we will supply you tomorrow.
Kindly consider.
No, no.
And it become infectious, not.
Finding infectious.
That will also decide finally. Spouse is main, that is no.
No, no, Mr. Krishna, you should understand. In fact,
Points
I
are
am trying to get
Object of object of the situation, object of the rule covered by situation as contemplated under rule 6(2)(c) appears to be that the spouses can live together. Fine.
Spousal without a government employee should not suffer. Whole half privileges to a government employee.
Yes, we have heard you, Mr. No, we have ordered this. See, please do not ask then now. Yes, we have done it. 445, 455. See, yes, next. Admitted for years. Huh? 43 to 46. This is. Yes. Monday? Mr. Rao, is it urgent?
That it can be taken up.
No, it depends on the round of counseling on which you are trying to notify.
Second phase of counseling, you are already
It will take some time.
No, so how much time do we have so that we can fix the date?
Up to first will.
Up to first?
Today started from today.
Huh?
2 o'clock in the Monday. First day. Up to first day, then 2 o'clock. Tomorrow it can. Web counseling is started from today, Lord. It ends with Friday, Lord. Afternoon.
We take it up tomorrow, Mr.
Tomorrow,
You said wedding. Sorry. Which then case? See, Monday, 4th September. Mr. Rao, what do you say? Monday, 4th September? We have time till 4th? No.
Counseling will be over. Counseling will be over.
Then, Mr.
That order is supplied to the.
It's modified.
Order is also modified.
No. See, interim order, see, non-compliance give rise to contempt. Please don't feel.
I'm not saying that the state was pressing for late. I'm saying that
The direction given.
See, his predicament, Mr. Rao's predicament is that he has to finalize the process. He cannot, but this being today, this transfer thing happened and full tank level happened, you see. So, PIL. So, we couldn't take up, we wanted to hear, that's why we passed over. And we are ready to hear tomorrow, but you are not available.
Last kindly say.
Friday, Mr.
Last kindly say, that this honorable could give a direction to consider the age certificate of the NCC holder. As per the GO, we have no, but the grace marks were added to age certificate holders. Therefore, Lakshmi put it tomorrow, it doesn't take much time.
Tomorrow his nephew is getting married or something like he has that problem he told us.
Lakshmi, Friday.
That's the thing, earliest 43 to 46 on account of paucity of time the matter could not be taken up. List Friday is what date? 1st of September 23. And what happens to item 50, 51? 48, call 48, madam.
48 is Vijay Krishna, P. Pusparani, GP for the.
Yes, 48 is what? What is it, mister? Without notice to the appellant. Who is there? Respond. Nobody is appearing. All right. So we should set aside, yes. None for respondent though served. Yes, this intra-court appeal has been filed against an order dated 22nd August 2022, passed in WP number 33066/2022, by which the writ petition preferred by respondent number 1 has been disposed of without giving an opportunity of hearing to the petitioner. Please sit down, mister. Sit down here. You are appearing in this case. Just sit down. Without giving an opportunity of hearing to the petitioner. Paragraph learned counsel for the appellant submits that the then you say appellant so and so, none for respondent number 1 though served, and despite matter being called in second round, right? None for respondent number 1 even when matter is called in second round, right? That's it. Then this intra-court appeal filed against us. Learned counsel for the appellant submits that the order that the appellant, you are the owner of the land in question. Huh?
I'm having a ban subject to the.
No, so what is the direction?
Not to interfere, doesn't matter, but in signature, the police is giving protection to.
Learned counsel for the appellant submits that the appellant is in possession of the land in question and the direction has been issued. Direction has been issued to respondents number 4 not to interfere with the possession. Full stop. It is submitted that the appellant was required to be heard before any before it is submitted that the appellant was arrayed as respondent number 5 in the writ petition and was required to be heard. Paragraph. We have considered the submission made by learned counsel for the appellant since the appellant has been since the appellant is vitally interested in respect of subject matter of the writ petition and the petition has been disposed of without hearing the appellant, the order dated so and so, passed by the learned single judge is set aside. Learned single judge is requested to decide the writ petition afresh after affording an opportunity of hearing to respondent number 1, the appellant as well as other respondents in the writ petition. Accordingly, the appeal is disposed of. Next. Yes, please. You were saying something.
This is also similar matter, this also similar matter as item 48, where the appellant has not been heard.
What notice has been given? Notice?
During admission itself,
No. This thing, notice of this writ appeal has been issued?
Yes, my notice has been issued, my lords, and
what is appealing?
First one.
So what do you say? He appears for respondent number 1.
Yes, for respondent number 1, a vacate stay has already been filed by him as well.
Vacate stay?
There's a stay operating.
Where is the? Yes. No, what vacate? See, his grievance is that he was arrayed as which respondent in the writ petition, Mr.
Fourth respondent.
Respondent number 4. Can could the petition be disposed of without hearing him? Same order. Supposing if you would have been respondent number 4, how can writ petition be disposed of without notice?
Respondent number 1, a private party.
You are not the petitioner.
You are the petitioner.
He is not the petitioner. He is appearing for the state of Telangana, right? You are appearing for state of Telangana, correct?
No, I am private party. Private respondent.
No, he is appearing for the writ petitioner.
Tell him he is not getting it.
Yes.
Tell him, your friend, tell him that we are asking him how can the order be passed without hearing you. Tell him this is the question he should answer. Tell him.
Yes. My lords,
please tell him. Go there and tell him, right?
My lords, I am vitally interested in the matter, my lords, and all I see.
Mister, you tell him because he is not understanding, right? So you tell him. Go there and tell him. Mr. Government Advocate, you tell him. that he is the petitioner, his petition has been disposed of without hearing the appellant. We are remitting the matter back, tell him. How you are defending the order passed by Leonard
I
Singh?
can understand. My submission is Mela.
That's what we are asking.
No, my submission is
No, your submission is that it can be decided without hearing the petitioner.
Mela, I can understand, madam. The problem is, Mela, repetition order is that only dispose of the application filed by the writ petitioner with regard to survey.
The appellant claims to be the owner of the land.
Not in the writ petition.
Mister, we can modify the order by saying that you will also be heard by this thing 2 and 3. No, but there is a direction for not dispossession.
Because it creates a presupposition of possession which is not there.
No,
This can't be done.
no, but
Fine.
my submission is, Mela.
Correct. It can't be done. Dispossession cannot be. He is claiming to be in possession, somebody not in possession seeking an ex parte direction. How can you justify, Mr. Order, Mr. Counsel, this sort of an order which has been passed? Why did you implead him then in the writ petition? You should not have impleaded. If he has nothing to do with the land, why did you implead him? Once you implead him, he is entitled to get an opportunity of being heard. Why did you implead him? It was your petition.
No, Mela.
This petition is filed. This intra-court appeal has been filed against an order dated 14th December 2020-22, by which writ petition filed by the respondent has been disposed of with the direction to district collector and tehsildar, Matampalli, whatever, Suryapet district, to decide the online application submitted by respondent number 1. It has further been directed that till the decision of the application, official respondents have been directed not to dispossess the respond number 1. Paragraph. Learned counsel for the appellant submits that the appellant is the owner and is in possession of the land measuring 0.20 guntas, and 2.20, not gunta, 0.20 acres and 2.20 acres of survey number 540/42 and survey number 540-562/4, respectively, situated Peda Vidu village, Matampalli Mandal, Suryapet district. Full stop. It is further submitted that the writ petition that
The extent of land, sir. Yes, it will come.
Mister, we have heard you. dictated the order in your presence. What else? I cannot type. If you can type the order, please. She is a human being. She will type it. And the moment it is brought before us, I will sign it.